10, 9, 8, 7, 6, 5, 4, 3, 2, 1.
The subcommittee will come to order. Without objection, the chair is authorized to declare recess of the subcommittee at any time. We welcome everyone to this morning's hearing on juvenile justice pipeline and the road back to integration. I must say how excited I am about the many witnesses and their perspectives on talking about fixing, helping, overhauling a system that protects our children. Before we begin, I would like to remind members that we've established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also remind all members that guidance from the Office of Attending Physicians states that face coverings are required for all meetings in an enclosed space, such as committee hearings. You may remove your mask only when recognized to speak. I would also ask members to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Now we'll yield myself time for an opening statement. Today, this subcommittee, and I must say with a great deal of excitement because this is an area of great love and affection for me and the work that we've done in years past in this committee. But this is an exciting time that this subcommittee will discuss several issues that impact youth in the juvenile justice system. It will examine recent trends in law and policy and their impact on the prosecution, incarceration, and treatment of juveniles. It will also explore effective methods by which we can reform our juvenile justice system. Historically, reform has been a monumental challenge, particularly when addressing our justice system. But reform always requires those whose hands are free, whose hearts are in the work, and who care for the results. As Abraham Lincoln once put it in his speech, a house divided against itself cannot stand. United, we need to stand on behalf of our children. When a series of litigation challenges across the nation demonstrated the lack of due process and protection for youth in the justice system, we came together as a Congress to pass the preliminary Juvenile Justice Act, and that is the Juvenile Justice and Delinquency Prevention Act. With JJDPA as their guide, many states have taken up the task of reforming your juvenile justice system and are doing well in places like Utah, California, Massachusetts, Illinois, the District of Columbia, Connecticut, and Washington State. Thank them for their vision, but there's so much more work to do. They recognize that an investment in our children and their future is an investment in America. As we make this investment, we must take into consideration childhood trauma and its impact on an already undeveloped brain when prosecuting, punishing, and incarcerating our youth. Scientific-based research has shown that adolescence is a distinct development stage that lasts from the mid-teen years into the mid-20s. In essence, the brain doesn't fully mature until at least 25 years old. Does that tell us about high school students, middle schoolers, and yes, young people who may make rash or irreverent or spontaneous decisions? Should that be their life? Should we have a way of addressing these young people? It tells us that during that time, brains continue to mature and develop throughout childhood and adolescence and well into early adulthood. As such, adolescents do engage in behaviors that are risky and sometimes dangerous. It's our responsibility as guardians of the future to be able to help to steer those individuals that have made such decisions to a brighter future. Even the Supreme Court recognizes this fact as demonstrated in its line of landmark cases from Roper v. Simmons to Graham v. Florida to JDB versus North Carolina, Miller versus Alabama, Mr. Stevenson, and Montgomery versus Louisiana, when determining the legal culpability of juveniles facing life without parole sentences. Although the conservative majority in the Supreme Court stated in Jones versus Mississippi that it does not overrule Miller, this deviation from precedent is a clear reminder that we must remain committed to enacting legislation that addresses juvenile life without parole more effectively. It's unacceptable. The United States stands alone as the only nation that sentences people to life without parole for crimes committed before turning 18. 25 states and the District of Columbia have banned life sentences without the possibility of parole for juveniles, while several others have no one serving this sentence. Congress has much work to do to make this policy consistent, meaning that it is irrational and maybe inhumane to sentence young people to life without parole for acts they committed before the age of 18. This work must be done in addressing this and other issues like juveniles in adult facilities, age-appropriate prosecutions, reentry fines and fees, probation, status offenses, solitary confinement. According to the ACLU, research has shown that solitary confinement can cause extreme psychological, physical, and developmental harm, resulting in persistent mental health problems or even suicide. Caleb Broder, whose family I met, whose brother I met, was a tragedy and a prime example of the psychological harm that may result from excessive isolation when he took his young life in 2015 after remaining in solitary confinement in Rikers Island, even to the point of being in his own feces, for simple allegations of taking a backpack. I might add that it was determined that the owner of the backpack wasn't in the country, that it wasn't an offense in the first place, but he couldn't get a lawyer. He couldn't get representation. He remained there for a very long time. We're at an inflection point where we can no longer sit on the sidelines and hope and pray things get better. We are summoned by our better angels to take up this task and to do what we are sent here to Congress to do, to act. I pay tribute to Caleb with legislation named after him, but we must do more. I look forward to hearing your testimony on how we can help the states in addressing these pivotal issues and thereby saving our children. It's my privilege now to recognize the ranking member's opening statement for 5 minutes.
Thank you, Madam Chair. Thank you to all the witnesses for being here, both in person and remotely. At today's hearing, the subcommittee will examine the issue of juvenile justice. But we should be discussing President Biden's inhumane border crisis. I was at the border again last week, and what I saw was maddening. The Biden administration is not acting to resolve the crisis. The solutions are not difficult, but it requires the administration to admit that there's a crisis and they created it. I think we should explore some simple statistics at the beginning of this hearing today. Over the past 2 months, 35,000 unaccompanied minor children have been apprehended by Border Patrol. You should see the conditions that most of them are in. I have visited those facilities. I've been in virtually every sector in the last 8 weeks. There isn't a single one of those children who hasn't been trafficked or transported by the transnational criminal organizations called cartels. These children have been placed into hands of very dangerous and inhumane coyotes who abuse and victimize many, if not most, of these children. There is evidence of an additional pernicious problem affecting children who are crossing our southern border. They are being rented and recycled. Testimony before Congress asserted that children as young as 5-year-olds are used by dozens of adults to cross our border and obtain release into the interior of the United States. In one case, a 51-year-old man bought a 6-month-old child for $80. On the other hand, there are exactly 0 juveniles being held in the United States Bureau of Prison Facilities. 0. Those are our federal prisons. And according to the Bureau of Prisons website, there are 15 juveniles being held in 3 contract facilities. We are here today talking about those 15, ostensibly, instead of the 35,000. Police Executive Research Forum tracks crime trends and recently found that juveniles seem to be, this is a quote, increasingly involved in shootings and other violence, in part because they're not in school, and school resource officers have been reassigned, close quote. And don't forget an emerging policy objective from some Democrats on the left to defund police or even elimination of police departments altogether. The concomitant spike in crime, including juvenile crime, has already demonstrated the danger in this rather facile and wrong-headed idea. Issues surrounding juvenile justice are state issues and should be left to the states. The only nexus the federal government has to the juvenile system in America is when Congress inserts itself into the process through the administration of grant programs. There are myriad issues that this subcommittee could be looking at that are relevant to the jurisdiction of this committee and the role of the federal government, issues that are of great importance to the American people. As I mentioned previously, the Biden administration has refused to address the humanitarian and security crisis at the southern border that continues to worsen every day. It has been 50 days since President Biden appointed Vice President Harris to solve the crisis, and she still has not even visited the border. I invite her and any member of this committee to join me at the border to see and hear firsthand what is happening. It is hard to solve a crisis when you refuse to acknowledge that there is a crisis. Over 2 months ago, I and other members of this subcommittee sent a letter to the chairwoman requesting a hearing to examine how the Biden administration's crisis along the southern border affects Homeland Security and public safety. Of course, we've not had such a hearing, and we renew our request to hold such a hearing in the near future. The President needs to reinstate successful Trump administration policies such as the migrant protection protocols that were working. And we need to update our asylum laws and address loopholes in our immigration laws that serve as magnets for UAC unaccompanied children and families to enter our country illegally because they know that once they get here, they will most likely never be removed. Specifically, we need to amend the Trafficking Victims Protection Reauthorization Act so that UAC from non-contiguous countries are treated the same as UAC from contiguous countries. And we need to address the impacts of the Flores Settlement Agreement that require UAC to be released from custody, even if they're with their parents. Even the Obama-Biden administration advocated for those fixes. That's why I introduced the Stopping Border Surges Act to make these changes. The Biden administration's border crisis also raises serious concerns about violent criminal gang activity. According to a 2018 Congressional Research Service report, there are also concerns that MS-13 may exploit the U.S. southwest border by bringing young gang members from Central America to the United States as unaccompanied alien children, or may recruit some of the vulnerable UAC to join the gang's ranks once in the United States. This is exactly where we see the intersection of the Biden administration's border crisis and the topic before us today. These policies have very real and sometimes very deadly consequences. Not too long ago, 4 juveniles were charged with murder in West Palm Beach, Florida. They were members of the violent MS-13 gang in the country illegally and suspected of being unaccompanied children. This is not an isolated incident. It was not an isolated incident. MS-13 is taking advantage of our open southern border and bringing in unaccompanied children who actively participate in criminal gang activities. When these unaccompanied children enter our juvenile justice system, they divert resources that could be used to help serve those who are not in this country illegally. So we see yet another disastrous consequence of the Biden administration's lax border security policy. I again thank each of the witnesses for being here today. Look forward to your testimony and hearing what you have to add to this important topic. I thank the chair, and I yield back.
I thank the ranking member and was delighted to yield to him, thank him for his passion, and to remind him of the great work of the Biden-Harris administration, particularly the humanitarian response that they have offered and the intensity of their work on the issues of the border and unaccompanied children. So I thank you, Ms. Biggs, very much. I now recognize the distinguished chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement. Mr. Nadler.
Thank you, Chairwoman Jackson-Lee, for holding this important hearing on juvenile justice, not, by the way, on immigration. It is particularly important to hold this hearing on juvenile justice in the aftermath of the Supreme Court's recent decision in Jones versus Mississippi. That decision, which makes it easier for courts to sentence children to life in prison without the possibility of parole, marks a significant break from the court's prior precedent. Previously, the court had issued a string of decisions restricting the imposition of these harsh sentences, based in large part on the significant and growing scientific consensus regarding the differences between children and adults and the recognition that we should view, treat, and rehabilitate children in our justice system accordingly. Prior to the progressive era, a period of widespread activism and social reform spanning the years from the 1890s to the 1920s, child offenders over the age of 7 were punished and confined with adults in harsh and overcrowded penal institutions. But early reformers and psychologists opposed incarcerating youth with adults and urged the creation of new institutions for youth that focused on rehabilitation. This work led to the creation of the New York House of Refuge in 1824, the first juvenile reformatory in the United States, and a pioneer in the treatment of children. By 1899, other states had followed suit and had recognized that children who commit crimes are different from adults. By the 1920s, our juvenile justice system had emerged. But over time, a system originally focused on rehabilitation and the differences between children and adults shifted to one fueled by tough-on-crime laws in response to an exaggerated rise of juvenile crime and delinquency. These laws resulted in disparate sentences, especially for African American children, deplorable conditions of confinement for sentenced youth, and the deprivation of constitutional rights. According to the Death Penalty Information Center and the Equal Justice Initiative, at least 366 people had been executed for juvenile offenses by 2005. Thousands more, including children as young as 13, were sentenced to life in prison without the possibility of parole. The Supreme Court slowly recognized that children are different. In 2005, it held in Roper versus Simmons that, quote, that the death penalty cannot be imposed upon juvenile offenders, unquote. In doing so, the court acknowledged, quote, the overwhelming weight of international opinion against the juvenile death penalty, resting in large part on the understanding that the instability and emotional imbalance of young people may often be a factor in the crime, close quote. In 2010, the court held in Graham versus Florida that the Eighth Amendment forbids life without parole sentences for juveniles convicted of non-homicide offenses. In 2012, it held in Miller versus Alabama, a case argued by Brian Stevenson, one of our witnesses, that mandatory life without parole sentences for juveniles violate the Eighth Amendment. The court's 2016 decision in Montgomery versus Louisiana applied Miller retroactively, finding that children are constitutionally different from adults in their culpability, and that the severest punishments should be reserved for, quote, the rarest of juvenile offenders, those whose crimes reflect permanent incorrigibility. The recent Jones decision, however, guts this precedent, and it sadly reaffirms our standing as the only country in the world that sentences children to life imprisonment without the possibility of parole for offenses committed before they turned 18. As we examine the impact of this decision and possible solutions, it's important that we also explore the full range of issues affecting justice-involved youth. This includes early intervention strategies for at-risk youth, particularly those who have experienced childhood trauma, developing appropriate confinement settings, and rehabilitation programs that will ease reentry when sentences are over. Some states have led the way on juvenile justice reform. I hope these reform efforts, will mitigate some of the harm caused by the Jones decision, retroactively and prospectively. But our treatment of justice-involved youth should not be based on geography. Congress must be an equal partner in these reform efforts, which includes examining the way our federal laws treat youth in our justice system. I look forward to hearing from our witnesses as we continue to explore these important issues. Thank you, and I yield back the balance of my time.
The gentleman yields back. It's now my privilege to recognize a distinguished ranking member of the full committee, the gentleman from Ohio. we thank Mr. Jordan for his support of this hearing, and he happens to have stepped away for another hearing, so we thank him very much. The ranking member will submit his written statement, and we appreciate that. We'll now proceed with witness introductions. And we have heard the stories presented in our opening statements, mine and Mr. Nadler, of where we are in this issue. Quintessential leader, visionary, in this effort, along with our other witnesses, is Mr. Brian Stevenson. Mr. Brian Stevenson is the founder and executive director of the Equal Justice Initiative, a human rights organization in Montgomery, Alabama. Under his leadership, EJI has won major legal challenges, eliminating excessive and unfair sentencing, exonerating innocent death row prisoners, confronting abuse of the incarcerated and the mentally ill, and aiding children prosecuted as adults. Stevenson has argued and won multiple cases at the U.S. Supreme Court, and him and his staff have won reversals, relief, or release from prison for over 135 wrongly condemned prisoners on death row, and won relief for hundreds of others wrongly convicted or unfairly sentenced. We are seeking a journey to reform, and we thank Mr. Stevenson for being willing to be part of that journey and that victory. Ms. Marsha Levick is a legal chief counsel and co-founder of the Juvenile Law Center since 1975 and is a nationally recognized expert in juvenile law. Levick oversees Juvenile Law Center's litigation and appellate docket and has successfully litigated challenges to unlawful and harmful laws, policies, and practices on behalf of children in both the juvenile justice and child welfare system. Ms. Levick has authored or co-authored numerous appellate and amicus briefs in state and federal appeals courts throughout the country, including many before the U.S. Supreme Court, and has argued both state and federal appellate courts in Pennsylvania and numerous other jurisdictions. She realizes the wrongness of the Jones case, and we're glad to have her here to help us reform this system. Mr. Brett Peterson, he is one who is working in the vineyards. Brett is the director of the Utah Department of Juvenile Justice Services. He's responsible for the operation and management of Utah's Division of Juvenile Justice Services. Brett also oversees the continuum of care in juvenile justice, including early intervention, shelter, detention, and long-term secure settings. He is committed to reducing the need for out-of-home placements, correlating the services provided with the leading research related to the adolescent brain development. He oversees the ongoing implementation of significant juvenile justice reforms in Utah. He is working in the fields, in the vineyards, and he sees our children and what can be done on their behalf. Thank you so very much. Let me thank Mr. Aaron Tolilofoa. He is a reality check for all of us, a young man who we should listen to. Aaron is the chair of the Emerging Leaders Committee with the Coalition of Juvenile Justice and has been a long-term advocate for youth justice reform. Aaron's advocacy efforts have led to the passage of numerous legislative reforms in Washington State, including Senate Bill 6160, which would allow minors convicted in the adult court to stay in the juvenile correction system until they turn 25, rather than being transferred to prison when they turn 21. Aaron was given 21 years for felonies he committed when he was 15 years old. He was sentenced to Green Hill School, a Washington State juvenile correctional facility that focused on juvenile rehabilitation, treatment with education and vocational training. He is there now. There he has become a leader in the community and joined in lobbying efforts with fellow incarcerated youth to promote juvenile justice reform. His voice is one that should not be ignored. Ms. Jessica M. Vaughn. Jessica is the Director of Policy Studies at the Center for Immigration Studies, a Washington, D.C. based research institute that examines the impact of immigration on American society and educates policymakers and opinion leaders on immigration issues. She has been with the Center since 1992. Her area of expertise is immigration policy and operations, covering topics such as visa programs, immigration benefits, and immigration law enforcement. Thank you for being here. I'm going to take just a moment to do something somewhat unusual, and that is to thank my members for being here, because this is important work. We have experienced a pandemic and a COVID-19, and we know that time is of the essence as we move to make change. So I want to thank Karen Bass, Val Demings, Lucy McBath, Madeline Dean, Mary Gay Scanlon, Corey Bush, David Cicilline, Ted Lieu, Lou Correa, Veronica Escobar, Steve Cohen for their presence here, along with our chairman of the full committee, Mr. Nadler. I thank my members of the minority, Mr. Jordan, Mr. Biggs, Mr. Chabot, Louis Gohmert, W. Greg Stubbe, Tom Tiffany, Thomas Massey, Victoria Sparks, Scott Fitzgerald, Burgess Owens. I know that we'll work together for what is good for young people. It is now my obligation, as I welcome all of our distinguished witnesses, to thank them for their participation. I'll begin by swearing in our witnesses. I ask that our witnesses in person please rise and raise your right hand. I ask that our remote witnesses please rise and raise your right hands. The witnesses who are in the room, please rise and raise your right hand. I ask that our remote witnesses please turn on their audio and make sure that I can see your face and your raised right hand while I administer the oath. May I see your raised right hand while I administer the oath. Witnesses, unmute and raise your right hands in a way that is visible in the screen. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God?
I do.
Yes, I do.
I do.
Let the record show the witnesses have all answered in the affirmative. Thank you all very much. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within the time, there is a timing light on the witness table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For our witnesses appearing virtually, there is a timer on your screen to help you keep track of time. To my fellow members on this committee, I want to indicate how much witnesses are part of the process of democracy. So we're very grateful. As I yield to Mr. Stevenson, it should be known, as Ms. Levick, that they have just recently been engaged in a Supreme Court case. Mr. Stevenson has a graduation speech, but he was willing to be with us because we must make change. Mr. Stevenson, you're now recognized for 5 minutes. Thank you so very much.
Thank you, Madam Chair, and it's my great honor to be with all of you this morning. I want to begin by just emphasizing the childhood trauma epidemic that we are seeing across this country. I don't think we've talked enough about the fact that there are hundreds of thousands of children in this country who are born into violent families, that live in violent neighborhoods, that are being shouted at, abused, mistreated in their early years. And what happens when children are treated in this way is that they develop trauma disorders, just like our combat veterans coming back from combat. When someone's constantly being threatened, their brain begins to produce these chemicals, cortisol and adrenaline, and they become hyperreactive. And these trauma disorders have lifelong consequences if we do not intervene. And we have the power and the knowledge to intervene and to deal with this trauma epidemic. And I believe it would not only lower crime and improve public safety, but it would save lives. But instead of doing that, when these children get to schools, we do the opposite. We don't make them feel safe, we threaten them. We have too many schools where teachers react to these children like the teachers are correctional officers and the children are prisoners. We have too many principals that act like wardens. We say, do this and we'll suspend you, do that, we'll expel you. And that threat mindset aggravates the trauma. And by the time some of these kids are 9 and 10 years old and someone gives them a drug, and for the first time in their life, they feel 3 hours of release and peace from the trauma and the stress. What do they want? They want more drugs. And some of these kids get to 11 and 12, and someone says, join my gang, we'll help you fight the forces that make you feel threatened. And what do? They join that gang. And we have to understand that dealing with trauma is at the heart of how we improve the lives of so many of our children. We haven't done it, in part because we've had too many people preaching a false narrative about children. Some have said that some children aren't children. Some kids look like kids, but they're not kids. Super predator myths and other distorted notions of child development have dominated our policymaking. And today is a day I hope we will recognize the era of that and change things. I believe that all children are children. I don't believe we show our commitment to children by looking at how well we treat talented kids and gifted kids and privileged kids. Our commitment to children has to be expressed about how we treat poor kids, abused kids, marginalized kids. That's the context. And we haven't done very well. There are these things that I believe we must do. Last month, Maryland became the 25th state that banned life without parole sentences for children. I believe the federal government has a critical role to play in leading this country. The United States Congress should end and ban life without parole sentences for children. Not just because the Supreme Court has recognized that that's important, but because this country has an obligation to lead in rebutting the false narratives that have shaped these policies. There is a critical need for us to do something about the fact that we still have children in adult jails and prisons. In 2003, a bipartisan Congress passed something called the Prison Rape Elimination Act. One of the critical provisions of that act was a prohibition on putting children in adult jails and prisons. But notwithstanding that act, today there are thousands of kids in adult jails and prisons where they're threatened, where they're sexually assaulted, where the risk of suicide is dramatically higher. And that abuse continues. And I believe we have to create an enforceable ban on placing children in adult jails and prisons, a ban that applies both at the state and the federal level. The bill was introduced in 2003 by Senator Sessions in the Senate, Bobby Scott in the House. It passed unanimously. I have to believe that this Congress recognizes the importance of ending the shameful practice of putting children in adult jails and prisons. And finally, I think we have to reckon with the distortions that have been created by lowering the minimum age for trying children as adults. We have 13 states in this country that have no minimum age for trying a child as an adult. I've represented 9 and 10-year-old kids facing 40 and 50-year prison sentences in adult jails and prisons. Last week, I was in California. I was celebrating a book release by one of my clients. A 13-year-old boy named Ian Manuel was arrested and convicted in Tampa, Florida. He was born into violence. His mother was put in prison for a violent act. He was abused. He was homeless. He tried to join a gang at 13, and he ended up attempting a robbery where he shot someone. And for that crime, he pled guilty, and the judge sentenced him to life imprisonment without parole at the age of 13. They sent him to an adult prison. And even though he was 14 years old, they couldn't put him in population, so they put him in solitary confinement. He spent 18 years in solitary confinement where he cut himself, where he was abused. We won his release after the Supreme Court banned life without parole sentences for children. He spent 5 years in our reentry program, and today he is a published author. He issues poetry. He is very, very acclaimed. He is an example of the problem and the solution. He represents the challenges, but also the hope of what happens when we commit to recognizing that all children are children. That's what I hope this Congress will do today in changing this narrative and lifting up the children who are most vulnerable in American society.
Let me thank you very much for your testimony, Mr. Stevenson, and the passion in which you have given it. I now yield to Ms. Levick for 5 minutes. I think you need to turn on your mic. Thank you.
Happy to do that.
Yes, thank you.
I'll start over. Madam Chairwoman Jackson-Lee, Chairman Nodler, Ranking Member Biggs, and distinguished members of this subcommittee, thank you for welcoming me today. At a press conference this past Saturday to address the civil rights charges recently filed by the Justice Department against convicted officer Derek Chauvin and 3 other officers charged in George Floyd's death, at which Chairwoman Jackson Lee was also present, Congressman Al Green from Houston proclaimed, "The winds of change are blowing." The winds of change are indeed blowing. I've been advocating for youth in the justice system since 1975. I co-founded Juvenile Law Center 1 year after Congress passed JJDPA, and just 8 years after the United States Supreme Court first declared that children are people too under our Constitution. The cries for transformation have never been louder or more urgent. Since 1975, I have seen the highest levels of youth arrests and incarceration, and I have also seen the lowest. 2019 saw the lowest number of youth arrests in more than 40 years, and youth incarceration has dropped by 70% since 1996. But even in the face of such steep drops, youth incarceration remains too high, and our youth are still suffering. Children are still experiencing physical, emotional, and sexual abuse in custody. We remain the last country in the United Nations to sentence children to die in prison, and racial disparities have only worsened in the youth justice system. Federal leadership can make a difference. Several bills have now been introduced that will set standards and provide guidance on how to establish a more humane justice system for our children. I will briefly highlight a few of these opportunities. Costs and fees. Over 10 years ago, I litigated the Kids for Cash case in Pennsylvania, an international scandal in which 2 judges were alleged to have taken nearly $3 million in kickbacks from the developer and owner of private for-profit youth detention centers. The greed and corruption were unprecedented, but the case also exposed a largely hidden system of fines and fees charged directly to kids and their families that kept them embroiled in the legal system even after their cases were essentially resolved. But just in the past 3 years, 7 states have passed legislation to abolish or substantially limit fees, and 9 have legislation pending this term. We're just at the beginning of this transformation. Federal-level incentives to reduce fines and fees would further spur these reforms. Conditions. Even 1 day of incarceration harms children's future outcomes. We still lock too many children up. And while these youth are often portrayed as dangerous, here's some important data. The majority of youth are detained, 62% of them are detained for property, public order, or drug offenses, not offenses against persons. The pandemic actually underscored a propensity to over-incarcerate. Custody levels dropped by about 24% at the beginning of the pandemic last spring, and these numbers have remained low. Too many children are still placed in isolation, pepper sprayed and assaulted by staff and others while in custody, with little recourse available unless they can jump through very complicated administrative hoops required by PLRA. Research has shown us that rehabilitation and programming are much more effective and economical when delivered to children and their families in their communities rather than in out-of-home placements. And while the number of state-run facilities has dropped by more than half since 2000, federal investments to continue this trend and support a continuum of care from prevention to intervention is essential, and it costs much less. Extreme sentencing. When Juvenile Law Center opened in 1975, children could still be executed. After the federal crime bill in 1994, nearly 250,000 children were sent into the adult criminal justice system every year. Today, children as young as 6 and 7 can be arrested in half the states across the country. The emergence of developmental and neuroscientific research in the last 15 years has changed or eliminated some of these practices. I served as co-counsel in Montgomery versus Louisiana and on leading amicus briefs in the earlier U.S. Supreme Court decisions that struck certain extreme sentencing practices for youth based on their developmental immaturity. But the United States still remains alone in its harsh treatment of children. That children are different from their adult counterparts is now established both in science and in the law. This principle must inform every aspect of our youth justice system. We must keep the youngest children out and provide those who remain the caring treatment and rehabilitation the system was designed to provide. The states have made good progress here. Nearly all states set 18 as the age of criminal responsibility. More than half have eliminated life without parole, and half the states have eliminated the automatic transfer of children to adult court. Yet our federal statute has no such boundaries. These aren't radical ideas. Reforms in the states, like at the federal level, are bipartisan. Conservative groups as diverse as Freedom Action Network, Americans for Prosperity, Our Street Strategies, and Right on Crime support these efforts locally and nationally. Let me close with 2 final points. In 1985, Nelson Mandela famously observed, "There can be no keener revelation of a society's soul than the way in which it treats its children." More recently, Justice Sotomayor wrote in her dissent from the Supreme Court's denial of cert in a case in which incarcerated individuals in Texas sought greater health and safety protections in the face of COVID-19, she wrote, "It has long been said that a society's worth can be judged by taking stock of its prisons. May we hope that our country's facilities serve as models rather than cautionary tales. I urge the members of this committee to keep these two truths close. Change and transformation are indeed possible in our youth justice system, but only if that system mirrors the core values of human dignity, racial equity, and true justice for all." Thank you.
Thank you very much, Levick. Time has expired. Now we recognize Mr. Peterson. Mr. Peterson, you're recognized for 5 minutes.
Thank you. Chairman Nadler, Chairwoman Lee, Ranking Member Biggs, and esteemed members of the subcommittee, my name is Brett Peterson, and I am the Director for the Division of Juvenile Justice Services within the Utah Department of Human Services. It is an honor to be here today. Our division operates early intervention, detention, community-based placements, long-term secure care, transition, and parole for youth up to 25 years old. We align within Utah's system of care model to change young lives while holding them accountable and keeping communities safe. System transformation does not happen overnight. It requires philosophical, policy, and practice change, and it will not occur without an unrelenting commitment to partnership. With this focus, Utah pivoted our treatment approach with public input and Pew research-based legislation in 2017. The fundamentals of reform include actively challenging the relics of a system that wrongly believed the best response to low-risk behavior was to incarcerate and institutionalize. We do not criminalize adolescent behavior, especially when overwhelming research shows treating children as adults only puts them on a path to worse behaviors and worse public safety outcomes. Buy-in involves consistent education about adolescent brain science, that children are different from adults. Not to mention, we know our youth are more likely to have challenges stemming from socioeconomic and racial bias, to be victims of trauma, and to be involved in other areas of human services, including mental health, behavioral health, disability services, and child welfare. Systemically, we promote and engage in policy decisions that support prevention, research models, equitable treatment, and the best public outcomes. In Utah, transformative policy change includes the following: strict limits on when a youth can be tried as an adult, the elimination of life without parole and death penalty for anyone under 18, the entitlement to free and effective legal counsel for every youth, the requirement of parental consent or legal counsel for a youth to waive Miranda, limitations on when and how school-based offenses can be referred to juvenile court, strict limits on lengths of stay and the use of contempt, assurances that youth may only be detained if they pose a public safety risk, mandates that programming must be evidence-based, the elimination of incarceration or court for youth younger than the age of 12, except for aggravated offenses, and the elimination of isolation, indiscriminate shackling, and limits on room confinement. A critical element of our pivot is to flow resources and savings to a no-wrong door early intervention model. We deliver trauma-informed care and ensure youth receive the right amount of treatment in the right settings. We establish free and voluntary services in the community to help youth improve risk behaviors, avoid any involvement or deepening in juvenile justice or child welfare system. We are pioneering new models and partnerships for vocational, employment, and higher education for every incarcerated youth. And data indicates our endeavor to transform a system is working. Since 2018, I can report the following: a 46% reduction in detention admissions, a 26% reduction in risk to reoffend, over 130 locked rooms taken offline, over $9 million in savings captured from a reduction in out-of-home placements, a 19% increase in early intervention programs, especially in our rural communities. Nearly 100 full-time employees have been reassigned from locked settings like detention to early intervention. Reform is a journey. It is not a destination. I recall speaking to a small child of 11, shaking as they sat in a detention center. I have come to know a youth who grew up in our facility, seeing them leave at 21 for prison for an offense committed when they were 15. We still witness heartbreak, tragedy, and loss every day. Our data shows disproportionate system involvement for youth of color. We do not have all the answers. However, we believe we will continue to see positive results through our proven philosophy, policy changes, and practice change. Youth today and generations to come will benefit from our nation's commitment to changing young lives when they need us most. Thank you.
Thank you very much, Mr. Peterson, for acknowledging that this is a journey. Thank you for your work. Mr. Tolofoa, and it's Aaron, and you can let me know whether I pronounced that last name right, sir. Good to have you here. We recognize you now for 5 minutes. Thank you.
Good morning, Madam Chair, to the committee as well. I thank you all for this opportunity to speak with you today. My name is Aaron Tolofoa. I'll be speaking to you from the state of Washington, where I'm incarcerated. Since the age of 15 years old and going through the system, I've learned that the system was created for us, but the thought of us being involved in the creation itself had not occurred. In other words, the system wasn't built by us, and therefore it makes sense that the system doesn't work for us. I say us directed at people of color and people from poor communities who are disproportionately impacted by the system. Many people who I've worked with, and as well as myself, have tried to stress the importance of bringing individuals who were and are currently incarcerated to the table when making decisions that may impact them or decisions that would make sense to have their input. Without authenticity, real change doesn't exist. So including those with lived experience alongside community outreach programs and organizations is the most effective way to ensure that our youth are properly provided the tools and are equipped with the skills to succeed wherever they are. For example, here in Washington State, for Asian and Pacific Islander youth like myself, we have an organization from my community called Tough Love that meets with the youth in the facility, and on our group meetings we learn about our culture and where we come from. We learn the values and morals and ways of our culture that we've been so out of touch with. We learn from someone who comes from a similar background as us, and when you find out more about yourself, you get a sense that you belong. And how many times do youth try to belong but find themselves looking in the wrong places? For instance, when suspended or expelled from school, youth who aren't receiving education at that time, now with this idle time, often find others who give them a sense of belonging, which is where we see youth engaging in criminal activity, hence the school to prison pipeline. Now, with our youth who enter the system, we speak about rehabilitation, but we need to ask ourselves, how exactly do we expect our youth to find rehabilitation in a prison setting? Since the beginning of COVID, those inside of the system have experienced isolation even more. Knowing the impact isolation has on brain development, you can assume, right, that incarcerated youth are experiencing a greater amount of stress and anxiety because of the many outlets and ways of coping that were closed off due to the pandemic. We're essentially hoping the at times hopeless, and for the most part helpless youth, to find hope and help within the environment they're thrown into. It's almost as if we're hoping a flower to bloom in a dark room. We have to become the light for our youth to grow and not the dark room that prevents growth. How this can happen is through understanding things like generational trauma, understanding what rehabilitates as much as what debilitates, understanding that its duty to the individual doesn't end upon release. This, as well as introducing love and care into the lives of youth who have been deprived of those essentials growing up. And what I feel is very important is actually talking to the youth who are incarcerated. Our youth who enter the system may often leave the system as legal adults. Not knowing how to function as an adult in society is a big factor in why they experience recidivism. If we hope to stop our youth who become young adults from reoffending upon release, we need to offer them real help. For youth with no money, we need to give them help financially. This means financial literacy programs and jobs where they can actually earn money and learn how to manage it. For youth with no housing, we need to offer them housing, or they're literally just being thrown out onto the streets. So we see that our system does a good job at holding those inside accountable for their actions, but what about the rehabilitation and reentry parts, which are just as important for not only our communities, but the youth themselves? For the youth who are sentenced as adults, one message from the system is very clear, that the system doesn't care about you. I believe in keeping our youth from the adult system, Being a part of passing legislation in my state, I've seen the positive impacts of extending the age a youth is able to spend in the juvenile system. Instead of being shipped off to DOC before their 21st birthday, they're able to make the best of their opportunities that are offered in the juvenile institution until their 25th. Opportunities like going to a community placement program instead of an adult prison where recidivism rates are tripled once you walk through the doors. So by keeping youth out of the adult system, we offer them better outcomes in their future. When it comes to changing how the system operates and what it looks like by passing bills into law, instead of talking about why it shouldn't work, we should ask how it will work. Thank you.
Thank you very much for your testimony, for your life story, and for your commitment. We hear you very loudly. I now recognize Ms. Vaughn for 5 minutes.
Thank you. My testimony will focus on a specific serious problem that is imposing an enormous burden on American communities and which will have lasting effects, including making it more difficult to resolve the justice pipeline issues under discussion today, but which this Congress so far has failed to address, and that is the crisis at the border. We are experiencing a border policy disaster. The number of apprehensions in April were the highest monthly total in 20 years, and Border Patrol agents say that the number who are successfully evading capture is higher now too, potentially double or triple that. Mr. Biggs went through the statistics, and they're very concerning. In addition to the huge numbers of families and kids arriving illegally and being released into the country, Border Patrol has seen a huge increase in opioids, fentanyl, and other lethal drugs that are coming in that is fueling the spike in overdoses in many communities today that we're seeing. The cause is obvious. The migrants call it La Invitación from President Biden. The invitation they're referring to is the loudly and clearly proclaimed reversal of the Trump enforcement policies that had successfully worked around loopholes in the law. And the Biden administration's move to essentially abolishing interior immigration enforcement through executive action, plus the promise to enact a mass amnesty for all those living here illegally and even many who were deported in the past. The resulting new surge of illegal arrivals is a major burden on American communities, so much so that 2 days ago, the governors of 20 states sent a letter to President Biden imploring him to end this crisis. The governors wrote, quote, "At a time when our country is trying to recover from once-in-a-generation pandemic, the last thing we need is a self-created crisis that exploits families, undermines public safety, and threatens our national security." The border crisis is a giant unfunded mandate for state and local governments. It severely strains schools, foster care programs, healthcare, and other support systems, the very same systems that are critical to shutting down the juvenile justice pipelines. Like the foster care system, kids in foster care are facing a disproportionate risk of incarceration, and many of them are Blacks, Latinos, and other minorities. Piling on huge new caseloads of unaccompanied minors will not help solve this problem. That is why 4 states so far have refused to participate in the Biden administration's unaccompanied minor resettlement program. And it's not just the numbers. The policies on placements of unaccompanied minors with sponsors are inadequate to prevent kids from being put in inappropriate and even dangerous environments. There is no meaningful screening of home placements or the people who come forward to take custody. Most of them are here illegally, and no meaningful monitoring of their welfare or activities after release from government custody. And they're here to stay. Our dysfunctional immigration system offers several pathways to permanent legal status for these minors, which they access with legal services provided by taxpayers. And those pathways include the Special Immigrant Juvenile Program and asylum. Another problem is the lenient policies at the border are deliberately exploited by transnational street gangs, especially MS-13, enabling them to significantly boost their activity here, both by sending gang members across our border to join cliques here, and also by providing the opportunity to recruit other vulnerable newly arrived youths. There is a clear nexus between the border crisis and the resurgence of MS-13 violence and crime, and especially juvenile crime. My analysis of 500 recent MS-13 arrests revealed that 43% of the MS-13 members that were arrested for murder in the last 5 years were under the age of 21, and many of their victims were young too. 23% of these murder suspects had apparently originally entered this country illegally as unaccompanied minors. Obviously, Congress cannot fix all of the social and economic problems that set the stage for juvenile delinquency, but Congress can act to fix our immigration laws that are making it so hard to resolve these problems. What Congress can do is update the TVPRA to clarify how arriving minors should be handled, with emphasis on swiftly returning them to their families in their home countries. Override the unreasonable Flores settlement agreement, require meaningful consultation and coordination with state and local governments on resettlement programs, end or rewrite the special immigrant juvenile program, reform the dysfunctional asylum laws, establish a baseline for mandatory minimum level of interior immigration enforcement, and especially act to preserve job opportunities for marginalized Americans, including young offenders, by boosting worksite enforcement and reducing issuance of certain temporary work visa programs. Thank you.
Let me thank you, Ms. Vaughn, and continue to emphasize the respect for the humanitarian approach that the Biden-Harris administration is now taking with unaccompanied minors. Thank you. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Mr. Stevenson, even Supreme Court Justice Kennedy, Senator Rand Paul, and others spoke against solitary confinement. I'm reminded of meeting Caliph and his family, as I indicated, 15-year-old who questionably took a backpack, who was incarcerated for 3 years, served 2 years in Rikers Island. That generates for me the pathway that we should proceed, and that is the emphasis, if you will, on barring juvenile from having life without parole, eliminating of juveniles in adult facilities, changing the age at which juveniles are prosecuted as adults. But going back to this point of Justice Kennedy and Rand Paul, when discussing the adverse and inhumane elements of solitary confinement, generally, as you well know, we'd introduced Caliph's law and intend to expand with the elements of banning the life without parole, eliminating of juvenile in adult facilities, and changing the age. I want you to collectively assess the cost analysis to these forms of treatment of juveniles. And as I do so, let me, if I may, subject into the record, Mr. Stevenson, science. Remember, we kept saying during pandemic, science, science. And so I want to introduce into the record the brain and emphasize the prefrontal cortex as a unanimous consent, and I submitted without objection, which indicates in young brains you have delay and reflect, inability to delay and reflect, inability to take all options into account, inability to contemplate risks and consequences, and inability to have social intelligence. Science. To all these that I've asked you about, Mr. Stevenson, would you please respond? Thank you so very much for being here and your leadership.
Yes. Yes, thank you, Madam Chair. Yeah, I think this is one of the issues where there is pretty wide consensus. Most wardens, most jailers, most institutional providers recognize the challenges that are created when we put children in adult jails and prisons. I don't know any that favor that policy, and yet we have thousands of kids in these facilities. And the dilemma for these facility providers is that when you put young children in population, these children are at risk of assault, they're at greater risk of sexual violence, they're at greater risk of abuse. And so banning the placement of children in adult jails and prisons seems to me to be the obvious and urgent next step. And I just want to reinforce what I said earlier. It's already been the expression of this Congress to prevent. The Prison Rape Elimination Act makes very clear that children should never be placed in adult jails and prisons without sight and sound separation. And yet, because there is no enforcement mechanism other than what the Justice Department can do, that continues to be a problem. That's why we believe that if this was adopted a law that provided a private right of enforcement, we could eliminate this problem very quickly. A year from now, we could come together and say that there are no children in adult jails and prisons, and that would reduce the risk and the challenges that are created by putting kids in solitary confinement. Khalif Browder, my client Ian Manuel, spent 18 years in solitary confinement where he was tear gassed, where he was abused, where he cut himself, where he was traumatized, and that's happening more and more. Our prisons are very violent right now, as Ms. Levick indicated. We are really having hard times helping these kids because of these legal restrictions, and that's why I absolutely agree that a ban on placing children in adult jails and prisons that's enforceable would be an immediate response. I also agree that ending life without parole for children would be a very, very logical and important next step. With 25 states, we've already done this. In 31 states, there are no children serving life without parole. We would commit to doing things that the court was indicating when they issued the decisions in Graham and Roper and Miller and Montgomery. And those interventions, Madam Chair, I just have to believe could be advanced. As I said, the PREA was passed unanimously just 18 years ago. We just haven't failed to implement. We haven't failed to implement it, and we need to do something about that now for the Khalif Browders and Ian Manuels, but more than that, for the thousands of children that are at risk right now in adult jails and prisons across this country.
Quickly, solitary confinement and being incarcerated without the ability for parole. Ms. Peterson?
Yeah, so thank you. When we look in our system, working with our partners at Department of Corrections, when they have a young person that, and it's incredibly rare in Utah that occurs, we've taken steps from a policy perspective to make sure that youth are housed in developmentally appropriate settings in the juvenile justice system. However, there are circumstances where they are still transferred to the Department of Corrections. When that occurs, they do have to be essentially in 23-in-1 type lockdown situations because they can't be in general population for their own risks. And so developmentally, it's really a step in the wrong direction to have them introduced into that environment.
Time has expired. Mr. Tolofor, the harm to young people in solitary confinement that you might perceive?
Yeah, from my experience, just entering a prison and seeing, what I used to see on TV, knowing that I'm going to be here, really was just like shocking because really it's like, man, this is what I'm going to be. This is where I'm going to be staying. So for me, mentally, it just wasn't healthy for me to, at that time when I was 17 years old, to experience that. So I think I'm with Mr. Peterson and disagree with just youth entering an adult prison, period.
Thank you very much. I yield now to
Thank you, Chairwoman Jackson-Lee and Chairman Nadler and Ranking Member Biggs for holding this hearing today. I'm pleased to welcome all the witnesses this morning, but especially want to thank my friend Brett Peterson, Director of the Utah Division of Juvenile Justice Services, for joining us today. I had the opportunity several years ago to move to Utah, where I fulfilled a 3-decades-old dream to work with at-risk youth. I started a nonprofit helping young boys and girls successfully transition from juvenile detention. It was Brett's JJS team that gave us the opportunity and framework to combine collaborative support from the state, educational institutions, including curriculum support from Utah Valley University, small businesses, Utah Home Builders Association, other respected corporations, and our greatest resource, community volunteerism. Second Chance for Youth now serves 3 facilities. We've had young men transition to higher education, including University of Utah and Salt Lake City Community College, begin careers, and most importantly, gain access to lifelong mentorship. I received a call last week from a young man who was part of our very first class. He now has a career, he's raising his family. He called me to follow up on my promise to introduce him to a specialist in the financial field to help him understand how to plan, save, and invest. I want to take this opportunity to publicly thank Brett, his JJS team, and my fellow Utahns for the remarkable hearts that they have for our youth. Before I begin my questioning to Mr. Peterson about the success of Utah's juvenile system, let me state that, that we need to be seeking state-centric solutions. Let best practice models coming from states like Utah and others drive this process, and our youth will win big time. And by the way, from personal experience, all these curriculum and intervention activities were all based on, were all evidence-based. I also want to take a few minutes just to thank Aaron. Your voice, young man, is invaluable. You're going to give hope to so many youth that need to hear that if I can do it, you can do it. So thank you very much. Ms. Peterson, when we talk about early intervention, what does that specifically look like in Utah? And can you give me some examples of effective early intervention?
Thank you, Congressman Owens. I think in any justice reform effort, there's often this question of now what? In other words, we used to have in Utah, for example, we had a very broad filter or funnel. Everything from very low-risk offenses to high-risk offenses were coming through the same doorways. They were coming through detention centers and courtrooms. And recognizing that we intentionally had to shrink that doorway, which we did. And now we have to say, how are we now going to flow resources towards the community? How are we going to serve people in their home schools and communities to help them thrive? So for us, what we stood up is our JJS Youth Services model. Truly what this is a no wrong door approach to early intervention. So it doesn't matter who refers to us, whether it's child welfare, whether it's a school, whether it's a parent, whether it's a youth walking in themselves, whether it's law enforcement. Regardless of how a youth comes to our door on this very front end, they can be sure that they're going to have, a dedicated case manager or plan manager. They're going to be allowed and afforded evidence-based screening tools, evidence-based assessments. And then the real game changer, because of reform, we're able to provide services on the very front end for youth and families. That was a tragedy of the juvenile justice system and the child welfare system. Before you could actually get to sometimes the more formal approaches of treatment, you had to be in the system. We're trying to flip that, and we're having success. So today, I want to highlight just a couple things. Our court referrals are down. Our non-judicial diversions are up. Our detention admissions are down significantly. I have less than 50 youth, about 50 youth in locked detention today, statewide. Our graduation rate's up. Certainly that's not all attributed to JJS. It's a system effort, Department of Human Services and collaborative with our partners in the courts and the schools. And what this corresponded with on a federal level is the Family First Prevention Services Act, which unlocked and gave us the ability to now access federal dollars for prevention work. That was a game changer, and it continues to be a game changer. So thank you for that question.
In the last few seconds we have, you mentioned 26% reduction in risk level for incarcerated youth. What was responsible for that reduction in Utah?
Thank you, Representative Owens. First, it really does start with reform. We have to make sure we weren't locking up low-risk youth. So in Utah, before reform, about half of the youth in my populations, incarcerated populations, were there. They were relatively low risk. They were there for contempt. They were there for maybe even, some types of misdemeanors, property crimes. So we had to stop that. We had to stop that pathway into the system. We had to really be looking at what's going to actually improve public safety. So we've done that. And today, when I look at my long-term incarcerated population, actually, not today, but Friday, May 7th, I had 72 youth total, statewide, in those settings. So that's step one. After we did that, we had to re-gear and reinvent our entire operations, focused on, we knew from the literature and the research, the amount of treatment we had to deliver for youth. We knew what would impact various criminogenic risks. We had to reinvent our entire operations subject to that linchpin, that point. So making sure every youth is getting the right amount of treatment, every youth is getting the right amount of dosage in the right way. And we set out with this ambitious goal of 25% reduction in the risk to reoffend by 2021. And I'm excited to be able to report that that's actually at 26%. So we beat our goal just barely. So thank you for that question.
I won't reel back my time. I just said thank you for your work, and this is the way we should look at best practices, and all our states can benefit from it. So thank you again, Ms. Priest, appreciate it.
Gentleman's time has expired. I now recognize the chairman of the full committee, Mr. Nadler.
Thank you. Mr. Stevenson, the Supreme Court has ruled several times in the past 15 years or so that children are constitutionally different from adults and must be treated differently for the purposes of sentencing. Can you tell us what these decisions mean for us as policymakers and how they should inform our work in reforming the way the criminal justice system treats children?
Yes, I think it's been really important that we have the courts intervene in this way. As was indicated earlier, in 2005, the court recognized that we could no longer execute children, and they rooted that decision based on an analysis of what we've learned about child development. We know that children are biologically different. Children change. It's the hallmark of being a child. And what was interesting, Chairman, is that we get this. You know, that's the reason why we don't let children drink. We don't let children smoke. We don't let children vote. We have all of these restrictions. Every state in the country recognizes that children are different than adults. The area where we have failed to make that recognition is in the criminal justice system. When we began prosecuting children, 13 years old, putting them in the adult prisons, 9 years old. When we started doing that, that's when we created the crisis that we are talking about today. There's a long line of cases. In Graham, the court recognized that imposing life without parole sentences on children makes no sense because children would change. And the argument essentially is that it's cruel to say to any child of 13 that you are beyond hope, beyond redemption, that you are fit only to die in prison. And that's what states are still doing. That's what the federal law still does. And that's why we believe it is so urgent that the legislatures catch up with this understanding that has been articulated. Mental health professionals have been preaching this for a very long time. We now have a critical need on the legislative side, given where the court seems to have drifted in the last year.
Well, thank you. We must give all children a second chance to live up to their full potential as adults. An investment in the future of our children is an investment in the future of America. April was Second Chance Month, and the administration spoke and called for automatic juvenile expungement and sealing of juvenile records to allow a successful path forward in their education and gainful employment. Ms. Levick, as the Biden administration has aptly stated, in states across the country, protections for juvenile records are inadequate. What should a concerted effort between the federal government and the states look like to allow kids a viable second chance?
I think that there are three critical issues that are raised in thinking about Second Chances Month, and thank you for that question. There are three issues. One certainly is providing for automatic expungement of juvenile records and sealing of records, and the federal government can certainly incentivize those practices. We know that even juvenile records can significantly adversely impact education opportunities, employment opportunities, and housing opportunities for our youth. And so thinking about automatic expungement is a critical way to avoid those kinds of challenges that our youth don't need to face. It's also true that extreme sentencing, abolishing life without parole, as we've already heard about in this hearing, is critical to thinking about second chances. The whole premise of the Supreme Court decisions in recognizing that youth not only should have hope, but that they also are entitled to second chances because of their capacity for change. Eliminating life without parole for children is critical to thinking about second chances. And the final suggestion that I would make is with reference to fines and fees. Fines and fees can have extraordinarily devastating impacts on both children and on their families. Why should families and kids have to make choices between paying those fines and buying groceries? But those fines and fees can also follow children after their juvenile delinquency experience. It can manifest itself in civil judgments that follow them, and again, can inhibit those opportunities that these youth should have for employment and housing and schooling. And so I think these are three critical areas where the traditional role of the federal government incentivizing states to adopt best practices can be undertaken here.
Thank you very much. Mr. Toliafoa, what are some of the measures your organization are reviewing that would address this problem to provide a second chance to juveniles?
So the organization that I work with, CJJ, obviously we work just around the JJDPI, AI, also really getting youth involved. I think that's really one of the main things is when we're thinking about giving them a second chance, not really just thinking, okay, yeah, here's a good idea. I think, this would work for them. Actually getting them involved and, asking youth, hey, like, what would work for you? Instead of coming up with an idea of our own and thinking that, it's going to work for them. So that's I think would be one of the most important things is really just getting youth involved.
Well, thank you very much. My time has expired. I yield back.
The chairman yields back. I now recognize Mr. Chavit for 5 minutes.
Thank you, Madam Chair. Juvenile justice is predominantly a state and local issue, not federal. Over 800,000 juveniles a year are referred to the state or local courts, and of those, there's usually around 60,000 that are incarcerated. As of this morning, there are 20 out of 60,000 that are on federal issues, and those are not housed in federal facilities. They're housed at state or local facilities. Now, where there is a federal issue is immigration, and the Biden border crisis, their failure to resolve this, and this administration's refusal to enforce our immigration laws. And its policies that incentivize the drug cartels who exploit children and juveniles and put the public at risk. That's what we ought to be talking about. That's what we ought to be doing something about. And that's what I intend to devote my time here this morning to. Ms. Vaughn, it's your testimony, is it not, that the current administration, the Biden administration, reversed policies implemented by the previous administration, and that's resulted in a huge influx in illegal entries into this country, many of those unaccompanied minors. Is that correct?
Yes, it is correct. There are a number of policies that have been reversed. First, the construction of the border wall was suspended. The Title 42 public health-based expulsions of everyone arriving illegally have been eased now, so that unaccompanied minors and most families arriving with kids are allowed to come in and then released into the country. It's basically the reestablishment of catch and release. The cooperative agreements with some of the countries in the region to share the responsibility of offering safe haven to asylum seekers, those are all in limbo now. And also importantly, the basically what amounts to a freeze on interior immigration enforcement also and it has helped send the message that if you can get to this country illegally, you will be allowed to enter and you will not face a threat of immigration enforcement for the foreseeable future. So all of this, and this sends a very powerful message that they actually call, as I mentioned, la invitación, that it's an invitation for people to pay criminal smuggling organizations to come here because they know they will be successful.
Thank you. And those criminal drug organizations, the cartels and the gangs, they're profiting immensely from this, aren't they?
Yes, I've seen estimates that it's a multi-billion-dollar industry every year. And the more that they can make off of smuggling families and kids and others here, the stronger they become and the more difficult it is for law enforcement to deal with them, the more money they have for bribes, the more resilient they are, and the less likely they are to give up this illegal trade.
And according to your statement, you indicated that the Border Patrol agents estimate that for every one illegal crosser that they actually apprehend, there's another 1, 2, or 3 who's able to evade their capture and gain entry into the U.S. So it's the numbers that we hear on TV, et cetera. The numbers are actually far more than we hear about. Isn't that true?
That's right, because of the number who are getting through successfully, because the Border Patrol is distracted by dealing with the arriving families and kids, and because there are not enough barriers along the border, there are not enough Border Patrol agents, they don't have enough support from the National Guard. Only Texas has invested some of its resources into assisting the Border Patrol in controlling this. And we're concerned about those so-called gotaways, especially because That's where most of the criminals and prior deportees and others that we really need to worry about,
Well,
they are in
stop.
that group.
Thank you. Let me stop you there because I've only got a short period of time. So the gotaways that you talked about, so they're not in the system at all. So we therefore have no information about who they are. We don't know the purpose of their entry. We don't know whether they have a criminal record. You mentioned MS-13. We don't know if these folks are connected with MS-13, although we know an awful lot of them are. We don't know whether they have COVID. We don't know if they have tuberculosis or hepatitis. And we also don't know in whose neighborhood these people are going to ultimately end up in. Is that correct?
That's exactly right. And they're spreading out across the country. We don't even know where they came from. And we know that people are coming from all over the world.
Thank you. My time's expired, Madam Chair.
Gentleman's time has expired. Thank you very much. I just want to remind members that we're here for the juvenile justice pipeline and the road back to integration, and also that children arriving unaccompanied from Central America are fleeing gang violence, not bringing it, and the increased levels of domestic, gender, and gang-based violence in these countries leave young people with no choice but to flee or face gang recruitment,
Madam Chair,
and gender-based atrocities or
point of order.
murder.
Point of
So
order.
let me yield now to the gentlelady
order,
from
Madam Chair.
California.
Point of order.
Ms. Bass.
Madam
Point of
Chair,
order.
Point of order.
What do you want me to do?
I understand. Ms.
Madam
Bass,
Chair,
you'll be
I would just note, I would ask if the.
You'll be
if it's a-
next. I'm going to recognize you
Point of
just a
order.
moment.
Point of order.
Just a moment. You'll be next. Thank you. Gentleman is recognized.
I would
for
just
point of order.
ask if it's appropriate for the chair to basically comment and get additional time over and above her 15, excuse me, her 5 minutes.
Yes, it
To
is.
comment on virtually every person on this side and to disagree with the witnesses and us.
Mr. Chairman, Mr. Chabot, Mr. Chabot, it is the prerogative of the chair to clarify the title of the hearing, and that's what we did. Thank you.
Well, I disagree, but you're in the majority.
Thank you, Ms. Chabot.
Madam Chair, Mr. Chair,
Ms.
Mr.
Bass from
Wright.
California is recognized for 5 minutes.
Why, thank you,
Thank
Madam
you.
Chair. And Mr. Chairman Nadler and Ranking Member, thank you so much for having this hearing, because my view of this hearing is that it's an opportunity to really look at a system that I believe is profoundly out of date and needs to be changed fundamentally to be consistent with the science that we know today. And so I want to raise some of those fundamental questions. And one of them, similar to my colleague, Mr. Owens. Mr. Owens started a at-risk youth project that I'd like to know more about. I did the same in South Central Los Angeles, and I found that working with some of the most challenging teens, that if they have an opportunity at a future and a life, they will go for that, and they will not go toward a life of crime. That's not a normal way to go. And so I wanted to raise a question. I wanted to ask Mr. Stevenson, who I think should get a Nobel Prize, and Ms. Levick, why do we arrest kids for status offenses? Why do we have status offenses? And what I found in South Central is that that was the gateway to a long life of interacting with the criminal justice system, whose families could not afford to take them off the escalator into prison. And I want to compliment my colleague, Steve Shabbat. I see he left, but I invited him to come to my district and meet some of the youth and see some of the programs, and he did that. And I appreciated that, because we cannot just say you can throw the life of a kid away. Kids don't come in isolation. They come with families. So can you please tell me, why do we have status offenses? Why don't we just eliminate that?
Well, we certainly should not be prosecuting and arresting children who are effectively charged with status offenses at all. Your points are all well taken. We're essentially trying to punish children for acting like children. We are singling them out for conduct that is not remotely criminal, that does not require the attention of law enforcement or other stakeholders in the justice system. and we harm them greatly. What we know from our experience, and certainly Mr. Peterson's experience in running the system in Utah, children don't benefit really from their engagement with the juvenile justice system. When we put them into that system, we always risk harm. Every day is a potential to risk harm to those children, and certainly sometimes to their families.
Thank you. Let me, before I run out of time, let me ask Mr. Stevenson to comment on that as well.
Yes, Representative, I think it's a really important question, and we didn't always do it. That's why I think it's so necessary that we recognize that we do not have to stay on this path. It's in the 70s and the 80s that we began criminalizing people for things that really weren't crimes. We said that people who are drug addicted and drug dependent are criminals. We could have said that people have a health problem and need a healthcare response. Making status offenses crimes and treating children like criminals was a consequence of what I call the politics of fear and anger. And that's why these interventions that you're hearing about in Utah, that you've talked about in Los Angeles, are so important. I absolutely believe that when we framed best interests of the child as the dominant controlling principle for how we dealt with children, we didn't put children in custody for status offenses. We need to return to that frame.
Well, I would argue that we still don't put certain children in prison. So status offenses, as I'm aware of, really are only problematic with children who are low income or kids of color. I don't know, because in my district, part of my district is very affluent, does not look like me, and I just never heard of a kid being ticketed or arrested for truancy or a status offense. So
yes.
I do want to ask the question about Utah, though, because I know Utah has wonderful examples, but does your agency deal with the for-profit part, the Sequel Youth and Family Services, Lava Heights Academy, Falcon Ridge? How do you interact with the for-profit? Because I also think that's one of the fundamental things that needs to be transformed.
Yeah, thank you for that question. So we operate ourselves, all of our detention, our shelters, our early intervention programs. We do contract with providers for a lot of our community placements. We don't currently contract with Sequel, for example. But what we do is, so most of our youth actually that are ordered into state's custody are actually served in the community in a residential treatment.
So if you don't contract with Sequel, which MSNBC, there was a special done on them, I'm sure you're aware of that. Do you have any ability to supervise them? Do you have any authority over them?
Well, I don't directly, but in our state, our Department of Human Services, Office of Licensing does have regulatory authority over any licensed providers in the state.
So I don't think our kids should be subjected to a for-profit industry, and I also don't think that only some kids, well, I don't think status offenses should exist, period, because it is a pathway to prison. I yield, I'm done.
Gentlelady yields back. I now yield time to Mr. Tiffany for 5 minutes.
Thank you, Madam Chair. First of all, Mr. Stevenson, I really appreciate the comment you made in regards to children are different. We don't have them drink, smoke, and vote. And I would just urge you to contact some of my colleagues who want children to vote and have put bills forward suggesting that they should vote. I would suggest that you may want to contact some of them and share that with them. Also, I just want to comment, Ms. Levick, I really do agree what you were saying in regards to fines and fees can be a real anchor for, especially when somebody comes out of incarceration. I saw it when I was in the state legislature, some of the really heavy fines and fees, that it is a real burden once you get out of incarceration to be able to handle that. So I really appreciate that you mentioned that. But I just want to ask a question of Mr. Peterson. You cited, I believe it was the Pew model that you guys used, and did you do some things differently than what the Pew model was, or what some other states that perhaps led in this direction before you? Did you do a few things differently than some other states kind of adapted to your situation?
I don't think significantly, no. I think that we primarily followed the Pew model and engaged with a pretty comprehensive working group to first establish, and looking at our own data. And so there's always going to be different data points in every system that might control the situation. But no, I think in general that is what we implemented.
Okay, and your working group, was it just within the state, or did you work across state lines?
No, just within the state.
Yeah, because I think it's really important. I mean, it's great to have a hearing like this at the federal level, but it really seems that if we want to see innovation and creativity being used here, it's once again, go to the states, the laboratory of the states, allow them to create the models. And if we use this cookie cutter approach, which really is a continual theme that is going on here, at least in the two committees I sit in Judiciary and Natural Resources, where we just look to the federal government to try to solve problems, we're going to create more problems that we can't handle. So, Ms. Vaughn, so you're saying there's a connection, there could be a connection between the border crisis and the number of youth offenders that are out there?
Well, there's no doubt that there's a connection between the border crisis and the influx of unaccompanied minors and families with kids with the resurgence of certain transnational street gangs, especially MS-13. And this is well known at state, local, and federal law by state, local, and federal law enforcement agencies. This gang, MS-13, is based in El Salvador and specifically sent out a directive a few years ago to its cliques in the United States to take advantage of the lenient border policies on unaccompanied minors to grow their ranks, to import new foot soldiers, essentially, for these cliques to increase the gang's revenue. And they also set about recruiting among the newly arrived youth in the communities where they were located. For example, there was a DACA recipient who was a member of MS-13 who was working at a middle school in Maryland, who's had contact with other kids and was able to use that to benefit the gang. There have been numerous other cases where the gang benefited by being able to bring in new recruits, and they're going to benefit now by this new influx and also the lack of interior immigration enforcement that will be directed against them.
So you're saying in all likelihood that we're going to see with UACs coming in, as they have been over the years, and unprecedented numbers now coming in, and by the way, unprecedented is the term that the Border Patrol uses, that some of them are going to end up in the juvenile justice system. Is that correct?
It's inevitable, and obviously most of the kids who are coming here are not potential offenders or gang members or going to end up in the justice system. The problem is that many of those who arrived as unaccompanied minors who are in the justice system are going to contribute to the problems, and they have taken advantage of these lenient offenses. So not all newly arrived kids are going to be criminals or gang members, but of the new criminals and gang members that we're encountering and that law enforcement is encountering, many of those entered as unaccompanied minors.
And I'll conclude, Madam Chair, by, first of all, I want to thank everybody for their testimony. I think this is really some interesting testimony. But to say that there is not a connection, as the chairman did, between illegal immigration and the juvenile justice system is simply inaccurate. We are seeing, when you have unprecedented numbers that are facilitated by gangs that are on the other side of the border, as well as in the United States of America, there is going to be an impact on the juvenile justice system. I yield back.
I thank the gentleman, and we'll clarify that going forward, but it's my pleasure now to yield 5 minutes to the gentlelady from Florida, Ms. Demings.
Well, thank you so much, Madam Chair, and thank you to our witnesses for joining us today. I also want to thank the chair for this very important discussion. I've worked as a social worker working with foster care youth, and I'm sure everybody in this hearing can imagine their stories. I spent time as a law enforcement officer and worked as a detective sergeant and a detective in the Crimes Against Children unit. As a police chief, I started a youth program specifically designed to help at-risk youth. I clearly believe that every child deserves to have an opportunity, and I think it's incumbent upon us as leaders, whether local, state, or federal, to design programs that give children every opportunity to succeed. But I think we fail as a system when we fail to address those quality of life issues that plague children in the first place, when we leave those quality of life issues to the juvenile justice system to solve. You know, and I do believe this is an appropriate forum as members of Congress to look at states who may have programs that provide best practices that we certainly can adopt. As we have a discussion about many other issues, and we are looking at what states are doing. Some of those states we're trying to prevent those things, and other states that are doing it correct, regardless of what the issue is. I think we're smart when we try to adopt best practices, especially I see investments in children's lives as a major investment in our future. And so, Mr. Peterson, if you could just talk again about the importance of intervention and how if we're going to give children an alternative to incarceration, how important intervention is into doing that.
Yeah, thank you, Representative. It is absolutely critical. Like you said, we can't address all the, when you start talking about the social determinants of health, economic instability and housing instability and healthcare instability, we're not that well positioned to do that in juvenile justice. We're going to do our best, and we're going to do everything we can to focus on reducing criminogenic risk factors, but fundamentally what we have to do, and the whole vision of reform, is to be able to reinvest, to flow resources into communities so that youth can stay there and they can thrive. So this can, it takes a lot of, I think it takes a lot of innovation. It takes an endless amount of partnership, but finding ways to listen, to hear. So our schools, for example, what's the challenge you're seeing? We recognize and we have a shared philosophy that we don't want to send a kid in front of a judge for truancy. I shouldn't say it's completely shared, but it's a journey. But then, like you said, how do we then help? How do we then help? So we partner. I have staff in some school districts where they actually go and they're staffing cases with the social workers in the school and recognizing, okay, maybe this family needs some more intensive, treatment. And we have the ability to actually fund. It can be youth or family, therapy, counseling, skill building, family group. It kind of goes the whole range, and we have that ability because of reform.
Thank you so much, Mr. Peterson, for that, and specifically talking about schools. Ms. Levitt, thank you as well for mentioning that we've come a long way. We still obviously have a long way to go. How we've seen the reductions in the number of arrests, leading to the reductions in incarcerations. But I want to talk to you, too, about how can schools play kind of a greater role in fostering those reductions that we see. If we know that the overwhelming majority of people in our prisons around the United States are Black and brown, and that they did not graduate high school, how can we continue to see those reductions in arrests and incarcerations by the school playing a better role in the process?
Yes, thank you, Congresswoman Deming. Such an important question. And I think it's important to start out by saying that roughly 39% of youth in the juvenile justice system don't graduate from high school. So that's precisely the problem that you've identified. I think that schools play a critical role. First of all, by not sending children into the juvenile justice system. And so we need to really be rethinking about, I think we lost our way in the last 20 years or so in pushing school resource officers into the schools, seeing schools
who were
really
placed in the school, by the way, initially for drug, addiction prevention and for
now they've become
prevention purposes.
And now they've become feeders into our youth justice system. That's exactly what we saw in the Kids for Cash case. All of those kids were coming from the school system. And these were kids who committed really trivial misconduct, not even offenses. And so I think that we need to start by focusing on schools as places of education. We need to recognize that we spend more money on incarceration than education. We need to change that funding balance. We need to invest in schools, and we need to invest in communities. I think your opening comments, the juvenile justice system can't solve the ills that plague our communities and that plague our families and our kids. It's not going to fix those problems. And so by investing in smart services and really investing in education, that's how we're going to find our way out of this.
Again, thank you to all of our witnesses, and thank you so much for the important work that you are doing, all of you in this space. And Madam Chair, thank you for being such a visionary and for this hearing. I yield back.
The gentlelady's time has expired. Thank you very much. Let me now to Mr. Massey for 5 minutes.
Thank you, Con.
Welcome. Thank you.
Thank you, Madam Chairwoman. Instead of asking one witness 5 questions, I'm going to ask all 5 witnesses the same question. But before I do that, I'd like to introduce into the record 2 articles, and this will give you an idea of the question I'm going to be asking you all. The first article appeared in The Atlantic, and it's by Elder G. Yusuf Qualls, retired pastor and criminal justice advocate. The article is titled, "Kyle Rittenhouse Deserves the Kind of Mercy My Son Did Not Receive." That appeared in The Atlantic. The second article is by Marcy Mistrit. She's the CEO of the national advocacy organization called Campaign for Youth Justice. This appeared in LA Progressive, and the title of this article is "Not Even Kyle Rittenhouse Should Be Tried as an Adult." So I ask unanimous consent to introduce these 2 articles into the record.
Without objection, so ordered.
Thank you, Madam Chairwoman. So that should give you an idea what my question is going to be. No surprises or gotchas here. I know you're not going to be jurists and you won't be judges, and you can't possibly know all of the circumstances of this situation. But what we do know is Kyle Rittenhouse was 17, and he's been accused of felonies, and he's being tried as an adult in Wisconsin. I'll start with you, Mr. Peterson. Please be brief. I want to give everybody a chance to answer the question. Should Kyle Rittenhouse be tried as an adult?
No, I don't believe so.
Thank you very much. Mrs. Levick.
I support that. I think that the science has taught us what we need to know about children. Kids are different, and we should treat them differently.
Thank you, Mrs. Levick. Let's see, Mr. Stevenson, sorry.
No, I agree with the panelists, but I will note that there's a 14-year-old named Omar Ninham in Wisconsin who has been tried as an adult and sentenced to life without parole. And what I want to do for Kyle Rittenhouse, I want to do for the hundreds of other children in Wisconsin.
Understood. And then finally, I want to ask Aaron to leave what your opinion is, Aaron.
No, I don't think he should be tried as an adult.
And then Ms. Vaughn? Should Kyle Rittenhouse be tried as an adult?
I don't know. I don't have an opinion on that. I do know that the border crisis and other problems with our immigration system are making it much more difficult to resolve this pipeline problem into the juvenile justice system. And I think that is an appropriate thing for Congress to be focusing on right now during this crisis.
Well, I thank you all for answering the question to the best of your ability. And I'll give you my opinion. I think but let me condition it. You all were nice enough to give a short answer, and I'll give the longer answer myself. I think it should be left up to the states. In Wisconsin, fortunately, Mr. Tiffany isn't here, and I'm talking about Wisconsin, but in Wisconsin, 17-year-olds are regularly tried as adults, but I do believe it should be left up to the states. I believe he acted in self-defense. That's just an opinion. I'm not a jurist or a judge. But if he's going to be tried, I think he should be tried as a juvenile. He was 17. He should not be tried as an adult. I agree with the 4 witnesses here who gave me a straight answer. I thank you for doing that. He shouldn't be tried as an adult. And adding to the absurdity of this case, he's also being tried for a misdemeanor crime of being a minor in possession of a firearm. So he's being tried for a crime that only applies to minors while simultaneously being tried as an adult. The only thing that would be more ridiculous if they tried him for the crime of being a minor in possession of a firearm as an adult. But that's almost how ridiculous this case is. So I thank you all for not having a double standard. I thank you all for standing up for the rights of all juveniles. And I hope that Kyle Rittenhouse sees justice, and I yield back the remainder of my time.
The gentleman yields back, and I now recognize Ms. McBath for 5 minutes. Thank you.
Thank you, Madam Chair. And I just want to thank each and every one of you that are here this morning, those that are here physically present and those that are virtually here with us today. Thank you so much for really talking about this extremely critical and important subject today. And I know that it's critical that we recognize the challenges facing our nation's children, and that we give them an opportunity to grow and learn from their mistakes. You know, we have long recognized that basic principle in our own justice system, creating different pathways in the justice system for youth and for adults. And that distinction exists for a reason. And when we erode that distinction, suddenly our children can end up in a system that wasn't designed for their needs and their circumstances. This is especially troubling for those youth who have committed the so-called status offenses that we just talked about. Actions or circumstances that are a violation of the law only when they are committed by a minor, such as skipping school or simply running away from home. When kids skip school, we need solutions that put our students back in the classroom, not in the courtroom. And I represent Georgia, and I'm thankful that Georgia took a good, deep look at how we were serving our youth in 2013. We decided that there was room for change. A council led by Republican Governor Nathan Deal found that we were spending over $90,000 per year to incarcerate our youth, and that expenditure wasn't solving anything. More than half of our youth ended up back in the justice system within 3 years of their release. Thankfully, Georgia redirected our taxpayer dollars toward evidence-based programs and policies. We put an emphasis on data and to keep evaluating our successes as well as our failures. Because when we get this right, everyone benefits. Our kids get back on the path towards success, our taxpayer dollars are used far more efficiently, and our communities are much safer. We have to keep working on these very goals, keep these very goals in mind. So I thank those of you that are doing this work every single day. You know, we must work together on a bipartisan basis to make sure that we're achieving a more humane environment for our incarcerated children. Mr. Peterson, I just want to thank you so much for the work that you've been doing in Utah. Like Georgia, Utah implemented a number of reforms, including different responses to low-risk behavior and also reducing the involvement of teens in our courts and jails. Do you have a sense of which of these reforms was the most important?
Yeah, I think that, you know, when I look at Utah, that we've definitely been on a journey, and we've had, you know, good bones in the system for a long time, if I can use that phrase, having a dedicated juvenile court bench, having a dedicated probation, a dedicated agency, and the right type of philosophy. But I do think that the most impactful was creating policies, those hardline guardrails on keeping low-risk youth out of the system. I do think that has been the most significant. When you start looking at our ability now to reinvest and to actually serve youth in their home schools and communities and not, you know, in a jail cell in a courtroom, that's been the most significant step in our policy changes.
Thank you for that. And Mr. Stevenson, it's so good to see you again. I'm so glad to have you with us this morning. And thank you so much for your commitment to justice and especially your work to tell the stories of Black Americans throughout our history. You know, we have to make sure that people understand our country's history of racial injustice, and that's the only way we're going to be able to achieve equality for all Americans. How can juvenile justice reform reduce socioeconomic and racial inequality?
Well, I do think it's a really important issue, and thank you for that question, because there are huge racial disparities. When we were looking at children sentenced to die in prison, all of the 13 and 14-year-old children sentenced to die in prison in this country for non-homicide offenses were Black. There are huge disparities, and even in the schools, the suspension rate for Black children and brown children is much higher than non-Black children. And so the disparities are key. And I think the most critical thing is recognizing that we have to be remedial. We have to be affirmative. We have to understand that bias, conscious and unconscious, is implementing and manifesting itself in the way we treat children of color differently than children who are white. And that has to shape our policymaking. And some states have done effective work on this, but being proactive, being intentional in eliminating racial disparities in education policy and sentencing policy. And I think that has to be a goal.
Thank you so much, and I'm out of time, but Madam Chair, may I ask that I submit a question to Ms. Levick and have it answered in the future?
Absolutely. All members are allowed to submit questions into the record, and the witnesses will subsequently provide answers. Thank you so very much,
Thank you. I yield back my
Congresswoman,
time.
for your line of questioning. I'm now happy to yield 5 minutes to the gentleman from Texas, Mr. Gomer. Unmute, Mr. Gomer.
Yes, I did. Thank you.
Thank you.
And thank you to the witnesses, and thank you for this hearing. I'm very much interested in ensuring juvenile justice in our nation, and I'm so glad that we all agree on that. Appreciate the witnesses very much. I find myself again perplexed that the majority would have this hearing and not address or even acknowledge the obvious elephant in the room. As Ms. Vaughn, you testified that February to March, we had 49,000 unaccompanied minors that were gathered in on our border. There's a lot of disturbing scenes at the border, whether it's little children being dropped over the fence, and as we saw down in Del Rio, little bitty children, even 1-year-olds. They didn't get to the border unaccompanied. They got there through the drug cartels. And I wanted to ask you, based on your study and what's going on, the control by the drug cartels, what will the drug cartels likely do to the children whose parents owe money for bringing the children into the United States?
Well, the cartels and smuggling organizations will use any tactics or means that they have at their disposal, including extortion, violence, kidnapping, and other ways to try to extract payment from the parents or others who pay them to bring the kids into this country. So it's horrifying, some of the things that have happened to kids. There are all kinds of abuses that occur because these are criminals who are doing a criminal business, and they're making so much money on it that they want to continue. And that's why we should not have policies that encourage people to contract and pay criminal smuggling organizations who are brutal and violent. It's our policies that are encouraging people to put themselves in these situations where they can be exploited, abused, hurt, or taken advantage of.
Well, thank you. It is staggering and it's scary what's happening to those children. It seems that the cages that were constructed during the Obama administration are not the worst things that are happening to those children as they're transported into sex trafficking and human trafficking, drug trafficking, to make the money to pay back the cartels for bringing unaccompanied to this country. But I quickly want to point to another problem that has arisen, terrible injustice involving young people. One in particular, Bruno Joseph Kua. He was from Georgia, lived on a 3-acre farm with his parents. He was arrested February 5th by a bunch of FBI agents in Atlanta. He was indicted as a high schooler in his senior year, including assaulting a police officer, possessing a dangerous or deadly weapon, which was a little baton that wasn't used. And we hadn't even There's not even evidence he assaulted anybody at this point, but he was whisked away, held in jail. The Justice Department is before Judge Moss, and they're arguing that this 18-year-old high schooler should be kept in jail. He shouldn't be released. And I'm quoting, I don't believe that home incarceration would work because he's an 18-year-old who's being homeschooled. That's Assistant U.S. Attorney Ryan Buchanan said. And so this case did not arise out of him traveling or going different places. It actually is the case of many dozens of cases. People committed the crime that many Democrats did of questioning the outcome of the federal election, and they're being punished, and he's being held in jail. He's a high schooler. There's no evidence that he's some terrible criminal. So we need to address all of this injustice for young people. And I appreciate, again, the opportunity.
Gentleman's time has expired. Now my pleasure to yield 5 minutes to the gentlelady from Pennsylvania, Ms. Dean, Congresswoman Dean.
I thank the chairwoman, and I thank you for assembling this important group of testifiers and experts. I thank you for your focus on our children and on the juvenile justice pipeline. Mr. Stevenson, it is good to be with you again. Thank you for your extraordinary leadership in so many areas of justice. I wanted to pull a line from your testimony. You said on page 1, this Congress should adopt new laws that increase the age at which children can be prosecuted as adults for any crime in the federal system. As you well know, the United States Supreme Court in Miller v. Alabama recognized that adolescents as a class lack the maturity, autonomy, and self-governing capacity of adults. Could you give us, in a more granular way, based obviously on the research and what we understand about children's development into adulthood, what Congress should do? What policies and new laws should we adopt?
Yes. Thank you for that question, Congresswoman Dean. I think, first of all, consistent with those Supreme Court decisions in Graham and Miller, Congress should pass a law banning life without parole for anyone in the federal system who is a child. 25 states have done that. I think it would send an important signal, not just to the states, but even internationally, where that practice has been prohibited for some time now. The second thing is, I do believe we need to create an enforceable ban on placing children in adult prisons. And this is an area where Congress was really controlling and trying to respond to prison violence at the state level. The Prison Rape Elimination Act was passed in 2003. It was about controlling a problem in the states. And I think this Congress should fulfill that promise of eliminating that by having an enforceable ban, create a private right of action so that lawyers can challenge the placement of children in adult jails and prisons. And the third thing I believe the Congress should do is to raise the minimum age. The gentleman was talking about Wisconsin. I don't believe any child should be prosecuted as an adult. I don't think we risk public safety when we do not prosecute children as adults. I think we can do more for children and the larger society by making that commitment.
Thank you very much. I follow up with you also on the other side of the juvenile's experience. Researchers found that juvenile experiences in correctional facilities can have a critical impact on whether adolescents successfully navigate the transition to adulthood, productive adulthood. What are some of the hallmarks of that experience that either determine they will be more successful or they will not be successful?
Yeah, this is where the evidence about trauma is so important. When you tell children at 5 and 6, at 7 and 8, that if they make a mistake, they will be suspended, they will be expelled, you actually aggravate their fear, their sense of being targeted and menaced. And that's why this kind of zero tolerance policy that we've seen in the education space has been so disastrous. We now put children, 6 and 7-year-olds, in handcuffs. And children never forget that. We put them in police cars. We send them to jails. We treat them like criminals. And that's what I believe we need to prohibit. There are states, you heard about that in Utah, that don't permit those kinds of practices. I think we need to see that. in more states. And the ultimate thing, I do think we have to influence educational policy, Congresswoman. You know, the Department of Education, when they evaluate schools, when they judge schools, when they grade schools, they don't look at suspension rates. They don't look at expulsion rates. And many schools have used suspension and expulsion as tactics to improve performance. That's been a recipe for increasing the criminalization and the traumatizing of young children that I just think no one should embrace. That's an area where education policy could intersect with juvenile policy. We could help a lot of children be healthy.
Great, thank you so much. Sorry, my time is so limited. Ms. Levick, if I could go to you. You were instrumental in seeking justice in the Kids for Cash case that took place in my home state of Pennsylvania, where some 3,000 children were placed in prison in exchange for financial kickbacks. That judge now behind bars himself. What safeguards were established in Pennsylvania to ensure corruption like the Kids for Cash case does not happen again? And what reforms should we be looking at here?
Well, I think one of the critical reforms, of course, was ensuring that children had a right to counsel. We had too many children who passed through the courtrooms in the Kids for Cash scandal that really had no access to lawyers, and we found that without lawyers, they were more likely to be placed and more likely to be adjudicated. So that's one critical reform that has been made. We've also required that judges actually state the reasons for why they're placing children out of their homes, because we know that every placement outside the home places children at risk for greater harms and abuse within facilities. I'm not sure if I should continue.
If you can,
well, I thank you for that.
If you can finish your sentence.
Has expired, but oh, go right ahead.
Finish your sentence, and
I can continue.
Finish your sentence.
Oh, I'm sorry. Yes, I think that what we have seen is that by really forcing, I think, exposure of what's happening behind the closed doors of the juvenile justice system has made a significant change in really holding that system accountable.
Thank you. Your time has expired. We now want to recognize Mr. Fitzgerald for 5 minutes.
Thank you, Madam Chair. My state of Wisconsin, is currently going through a reform of juvenile justice, more based on as much changes to the physical construct of the entire state. There were some issues in a juvenile facility located in central Wisconsin, but the legislature, I think, is trying to wrap their arms around what those reforms and changes would be. Antiquated facilities is one of the issues that certainly needed to be addressed. But I want to go back to some of the earlier discussion. I know Mr. Tiffany talked a little bit about it, and it is kind of this transfer that's been happening throughout the nation. We talked about a pipeline of juvenile incarceration and issues related to that, but there really is kind of this operation, this nationwide operation where children are being exploited. And I think, many of us have certainly dealt with the issues or talked about the issues related to human smuggling and trafficking and the drug-related crimes there as well. I wanted to ask Ms. Vaughn, along those lines, as we continue to see kind of that exploitation, and then the end result of those children that are incarcerated. It all goes back to these cartels, and we've actually had federal charges that have been levied against some of these individuals coming out of the Milwaukee districts as of late. If we don't stop or hold back the tide of these crimes related to those issues, how do we address kind of the whole juvenile justice system? We cannot forecast or predict the amount of juveniles that are coming into the system right now. And I think that is just as important as anything we can do kind of on the back end as these children are incarcerated.
That's right. And we had started to see some lower numbers in terms of juvenile offenders, but this influx of minors, many of whom do end up becoming involved in gangs or crimes, either to pay off their smuggling debts or the smuggling debts of their parents that they paid to bring them here, or because they are vulnerable and exposed to gangs in the schools or in the neighborhoods. All of that is going to complicate and undermine efforts to improve outcomes for youth. And I have to add, to the extent that one of the most important things to interrupt this so-called pipeline is to provide job opportunities for youth. And right now we're seeing very, very low employment participation among America's teenagers, especially. And teenagers are one of the groups that are most affected by our country's failure to control illegal immigration. Illegal employment displaces Americans, especially young people, especially people who lack a high school education for whatever reason. It displaces them from job opportunities and depresses their wages. And access to employment is one of the things that could keep our youth and others who are vulnerable out of the justice system altogether because they're gainfully employed. And that's another reason why we want to stem this flow of uncontrolled illegal immigration.
Thank you very much. The one other comment I just wanted to make, because it came up a couple times, is I know there's different titles for them, but school safety officers. And the comment was made that somehow that is adverse or a negative force on schools. And I have found that whenever you talk to a high school principal or a counselor, the relationships that are built and the understanding that's gained by these individual officers being within the schools certainly outweighs any negativity you might say that would be on the back end of this. I always thought that it was probably the best way for law enforcement also to establish kind of a different profile than what a youth may experience if they end up in a situation with direct contact with an officer on the street. So I just wanted to make that comment, and I yield back, Madam Chair.
Gentleman yields back, and now I yield to Mary Gay Scanlon, Pennsylvania, for 5 minutes.
Thank you, Chairwoman Jackson-Lee, for holding this important hearing. And thank you to our witnesses for testifying here today. I want to particularly recognize my fellow Philadelphia lawyer, Marcia Levick, whose decades of work with the Juvenile Law Center has been so instrumental in ensuring that the phrase access to justice also applies to children. Some of my colleagues have expressed concern about whether the federal government has an appropriate role to play with respect to juvenile justice. My view is less circumscribed, but I want to focus on a particular federal issue, and that is the Prison Litigation Reform Act, which governs the circumstances under which an incarcerated person can bring a civil rights suit in the federal courts. The PLRA applies not only to adult prisoners, but also to the thousands of children confined in prisons, jails, and juvenile detention facilities. My district is home to the now shuttered Glen Mills School, the oldest school for delinquent boys in the country, founded in 1826. But for years, its bucolic campus masked serious daily violence inflicted upon the children placed there. An explosive 2019 report by the Philadelphia Inquirer revealed years of physical, sexual, and psychological abuse of the young residents, including broken bones, threats, and sustained physical assaults at the hands of staff members. Although the stories from Glen Mills were heartbreaking, they're not unique. Physical and sexual violence, harmful restraints, and solitary confinement have been documented in juvenile facilities in almost every state. And unfortunately, states have not adequately protected children. Despite the recent example of the Glen Mills School in my district, this past March, children were removed from another facility, the Delaware County Juvenile Detention Center in Lima, after horrifying reports of abuse. The purpose of our juvenile justice system is supposed to be rehabilitative, not punitive. And when juveniles in detention are subject to physical and psychological trauma, it causes disproportionate harm. From Roper to Graham, Miller, and beyond, the Supreme Court has long held that juveniles lack the maturity and mental acuity to be treated as adults in our justice system, So, Ms. Levick, the testimony we have before us today speaks to how youth are at particular risk of harm in juvenile and criminal justice facilities due to their youth and developmental immaturity. Can you talk about the Prison Litigation Reform Act, or PLRA, and how it creates obstacles to young people facing abuse to seek relief in the courts when the detention system fails to protect them?
Yes, and thank you for that question. So the same folly that I think the U.S. Supreme Court has recognized in treating children like adults for sentencing purposes is reflected in the inclusion of children in the Prison Litigation Reform Act as it was originally drafted. The assumption that children can jump through the administrative hoops that PLRA requires, can file grievances, can figure out how to file grievances. Often youth who are in these facilities don't even have access to counsel. In many jurisdictions across the country, lawyers are simply not a part of that post-adjudication experience. And so I think the leadership that you have shown in really asking Congress to change a provision that really makes no sense. It is not reflective of the difficulties that children face in these facilities. And what it does, of course, is that it places children at great risk. I have been involved in litigation, of course, in the Glen Mills litigation. I was involved in the litigation in Wisconsin. And so we know that kids face extraordinary forms of abuse and trauma in these facilities. If we don't give them the ability to challenge and to address and to fix those kinds of abuses, then we are doing more harm to our children, even than by bringing them into the system. And so I really think that the bill that you've introduced that is designed to really spare children these extreme administrative hurdles to be able to file litigation is critically important to redress the harms that they suffer inside these facilities, and I thank you for that.
Thank you, and thank you for mentioning the Justice for Juveniles Act. We did pass it unanimously on the House floor last term, and I would invite members of the committee to join me again in supporting the bill. I mean, just to sum up, would it be fair to say that juveniles are both more likely to be abused while in detention and less likely to be able to pursue relief?
I would say that that's an excellent summing up of their dilemma.
Thank you, and with that, I would yield back.
Gentlelady yields back. Thank you for that insightful proposal. And I'd now like to yield to the gentleman from Mr. Student.
Thank you, Madam Chair.
5 minutes. Thank you.
Thank you. We've heard testimony today about violent crimes committed by juveniles associated with MS-13 and other Central American gangs, including murder and rape. We have also seen violent juvenile crime right here in Washington, D.C. This March in Southwest D.C., 13 and 15-year-old girls murdered a food delivery driver in an attempt to steal his car. He was just trying to do his job, and they killed him in broad daylight a little over a mile from where we sit right now. Violence like this occurs all over the country. For instance, in 2014 in Tacoma, Washington, a 15-year-old shot a man at close range with a rifle during a carjacking. According to a letter by the victim's family to the sentencing court, the victim lost use of his arm for a period and was left not fully able to work or care for his daughter. The victim is lucky to be alive after he was shot. The teenager convicted of these crimes would go on to be charged with a felony count of rioting in prison just 2 years ago. And the convict I'm referring to is Mr. Talafoa, and he's here today testifying by invitation of the chair about how he needs more opportunities in prison. Despite the horrific nature of these crimes, we continue to hear calls to not fully prosecute the criminals that are responsible for these crimes. It's all part of the defund the police agenda. For example, a prominent spokeswoman for the Black Lives Matter movement recently said that teenagers have been fighting, and I quote, with knives for eons, and we don't need police to address these situations by showing up to the scene and using a weapon. So I guess police are just supposed to let people stab each other. This is a dangerous ideology, and combined with the flow of criminals at the southern border, it's made even more dangerous. Ms. Vaughn, I have a couple of questions. In your testimony, you describe MS-13 and the 18th Street Gang as, I quote, extremely vicious and unusually degenerate. Can you provide some further examples of the crimes they commit and how juveniles are involved in those crimes?
Well, there are numerous examples of this. We have examined about 500 cases of MS-13 arrests nationwide in the last 15 years. And there are sometimes unspeakable violence associated with these crimes, whether it's hacking off people's limbs or luring people to parks in order to dismember them and bury the bodies. Some of the victims have not been fellow gang members, or sometimes they are youth who they thought might have been involved with a rival gang, or simply people who were killed because these kids are trying to prove their value to the gang and are expected to carry out random senseless violence in order to be accepted into the gang, and they're eager to do that, so they will pick out random victims to do that. um, it, it, um, it these gangs lure kids in a very predatory and frightening way, that also makes it difficult for them to escape from the gangs. But my research of both state databases and other federal crimes has found that these transnational gangs, and MS-13 in particular, are especially prone to violence, that many of these members are violent by the time they get here and are less afraid of the consequences from law enforcement, which makes them bolder, less wary of committing violence against a police officer, for example, or a teacher, or a kid who's not involved in the gang. It is a problem that is exacerbated by our failure to control the entry of these individuals over our border. And it's one that is making it hard for kids who are in the same schools to get meaningful education, to avoid entanglement with these gangs, and it's ruining the quality of life in some neighborhoods.
Well, you just hit on the challenges that we're seeing at the border and how this is causing increased amount of crime, especially with juveniles. Under Biden's border policies, violent criminal gang members under the age of 16 are not subject to removal. Can you explain the consequences of this and how MS-13 will exploit this?
Well, the gangs are well aware of the policies. They know more about our border policies than most Americans do. They know that a kid who arrives and claims to be under the age of 18 will likely be lightly screened. If we happen to have their fingerprints, they might be interrupted, and the Border Patrol is catching more gang members than ever before at the border. But usually they're sent to a residential facility with other kids where they also have the opportunity to recruit, and eventually released to sponsors who are very lightly vetted, often not fingerprinted or submitted to rigorous background checks. And they're free in the community to work for the gang, to work other jobs, and live here indefinitely, and often even receive permanent residency here.
Thank you for your testimony here today. My time's expired. I yield back to the chair.
Thank you, Mr. Stube, for your testimony. Gentleman from Florida, we appreciate your testimony. You were not here, and seek a clarification again. I just want to clarify that this hearing is entitled Juvenile Justice Pipeline and the Road Back to Integration. Gentleman from Florida was not here when Mr. Massey made a very eloquent point about a juvenile that killed 2 individuals in Wisconsin, and he raised the point of that individual being tried as a juvenile, and I imagine he made the same point about that juvenile possibly not being incarcerated with adults. Now, let me say that when we invite witnesses here, we expect courtesies to be extended to the witnesses. We don't have any quarrel with witnesses, in essence, being questioned, but Mr. Tolofoya is a young man who has made a seismic contribution to this nation, and I will not allow him to be disparaged. His advocacy has saved lives because he's led the passage of numerous legislative reforms in Washington State, and he has been the leader of disallowing minors who are convicted to be in an adult court to stay in the juvenile correction system until they're turned 25. In essence, those minors convicted in adult court are able to stay in a juvenile correctional system until they turn 25. He is a credible contributor to this process, and I wish that that would be noted by our members in a respectful manner.
Madam Chair, I have a parliamentary inquiry. My inquiry is this. When a member of the committee makes a comment or makes a statement that is not violative of our rules of decorum, is the chair entitled to rebut the statement of that member of the committee? And how long will this go on?
Thank the chairman for his question. As chair, I have discretion to run the committee hearing as I believe is appropriate. In this instance, the challenges to a witness in terms of that witness's credibility, that was not in the form of a question to the witness. I wanted to make sure the record was clear, and I'll move now to the next speaker. And thank you, Mr. Biggs.
Well, there was nothing that I did to challenge.
Let me yield to...
presented the facts to this committee and to the American public.
Let me yield to the gentlewoman from Missouri, Ms. Bush, for 5 minutes.
St. Louis, and I thank you, Madam Chair, for convening this hearing. In my home state of Missouri, Black youth account for 15% of our youth population, yet receives 27% of referrals to juvenile court. In the St. Louis region, Black girls are 11 times and Black boys are 18 times more likely than their white peers to be suspended from school. These zero tolerance policies regularly do not take into account, they do not take into account the social conditions in which children may live. Unsafe and unstable housing, lead exposure, which is to no fault of their own, cyclical violence and trauma in their communities, no fault of their own. And instead, they force our children out of school for acting out and fueling the school to prison pipeline. It is this fear of Black and brown youth, long labeled super predators, that has made jailing and sentencing them to life without parole too easy and too common. The stereotype that Black and brown boys and girls are dangerous or threatening has normalized systems of trauma, the cradle to prison pipeline, foster care, youth detention, and being tried and sentenced as adults. We treat trauma with more trauma. We treat Black and brown kids who can't vote yet, can't join the military, can't rent a car or even buy a lottery ticket like adults in our criminal legal system. We deprive them of their joy and their youth. Children who deserve to live rich and abundant lives, children who should be allowed to make mistakes, to learn from their mistakes because we did, to grow up and live productive and loving lives. Children like all other children. These children are young. These are children. They're young people who need love and support, that love and support that our communities should give in our government. Mr. Telefoa, thank you for being here with us today and for sharing your story and your incredible work with all of us. Thank you for that as we strive to build a more just America. Can you please tell us about the trauma and the lasting harm that incarceration can have on young people?
Yeah, so speaking of trauma and harm, a couple of weeks ago, I had gotten a call from one of my friends who was sent up to prison, and we were on a three-way call, and I was asking him, like, how are you doing? And I asked him, what was it like when you first got there? And he said, well, the first thing that he did was go and take a shower, and once he walked into that shower, he seen a dead body laying on the floor. Mind you, he's 18 years old, first going into prison. And thinking about that was his first experience when going into that shower, he just seen a dead body, and thinking about how young he was and how he experienced that. I personally don't think that he's ever going to forget something like that. He's going to carry that on to when he grows up to, take on adult responsibility. So when we think about just trauma and the harm that being in an institution can cause, I feel like that just experience right then and there kind of expresses the totality of it.
Absolutely. Thank you for sharing that. Thank you for sharing that. That is the truth of what is happening to our youth. That is why trauma-informed care also, that care and support needs to be prioritized in this space. Thank you. Mr. Peterson, what holistic alternatives to incarceration exist for young people?
I'm sorry, can you repeat the question?
Sure. What holistic alternatives to incarceration exist for young people?
Sorry, the list of questions, sorry, you broke up just a little bit. So for us—
Holistic alternatives.
Oh, holistic alternatives, thank you. Someone said earlier how it's so important that we can't view youth out of context. So we can't have a youth enter the system and all of a sudden not recognize the community or family that they're from. So it could include things that are very informal. So for example, during COVID, when we looked at our youth and our families, we recognized, they couldn't have visits the way they used to have. And so we had to switch to a virtual platform. Well, there's a big digital divide in a lot of communities. So we had to think of ways of, maybe the family needs something as simple as a smartphone. Things like that are these kind of holistic approaches. Or maybe they do need something more intentional and more focused, like some type of evidence-based treatment with the youth and the family. And for us also holistic, when we're talking about holistic, we have to look at educational
I only
opportunities.
have a few more seconds. If you could, yeah. I'm sorry.
That's okay.
I'm sorry. I have one more question that I need to get in, but thank you. Mr. Stevenson, your work has always been rooted in a deep commitment to justice and a belief in redemption. Can you tell us why it is important to extend mercy and compassion to children and young people? Mercy.
Well, thank you, Congressman Bush. I think mercy is at the heart of a just system. We've been governed by this idea that we can put crimes in jails and prisons. And you look at some of these sentences and you look at some of these policies, it's as if we think we can punish crime. But the truth is, we can't put a crime in prison. We put people in prison. We put children in prison. And I don't believe that people are crimes. I don't believe that children are crimes. And the difference between a crime and a child is what dictates that we think more compassionately, that we embrace mercy when we think about these policies.
Thank you. Thank you, and I yield back.
Madam Chair, I ask unanimous consent.
I thank the gentlelady. The gentleman's not recognized. The gentleman has a inquiry, or?
I'm asking for unanimous consent.
All right, the gentleman's recognized for unanimous consent.
Thank you, Madam Chair. I ask for unanimous consent to enter into the record the unpublished opinion filed July 9th, 2020 in the Office of the Clerk of the Court, Washington State Court of Appeals, Division 3, State of Washington v. Aaron Ada Talafoa, which states, in facts, in 2014, Aaron Talafoa engaged in a crime spree that ended with a near-fatal shooting. He was 15 years old at the time. Mr. Talafoa was charged with 8 felonies and 2 misdemeanors. The juvenile court declined jurisdiction, and Mr. Talafoa eventually pleaded guilty to a reduced set of charges, including attempted second-degree murder.
Without objection, again, I have never heard of members trying to disparage witnesses in the way that this is. Without objection, your document is submitted into the record. It does have any reflection on the gentleman who's here before us today. We thank him for his presence. With that, allow me to yield to Ms. Sparks. Ms. Sparks, are you present? All right. Then we will be able to yield, I believe, to Mr. Biggs, ranking member of the subcommittee. Thank you very much.
Thank you, Madam Chair. Appreciate that. And I know that we've been reminded repeatedly from the majority that this is about juvenile incarceration and how we treat juveniles. I was looking at Arizona's, and we've been focusing on the inhumanity of the treatment of juveniles in the Biden border crisis. But here's the thing. I was looking at the Arizona juvenile information, and there's a relationship to those who are illegally in the country in the Arizona juvenile system. We see the discharge of some to ICE, et cetera. It does impact virtually every community. It impacts Utah, Arizona, impacts New Mexico, Texas, California for certain. And to deny that, and that it doesn't have some role in the pipeline that we've been discussing today, just frankly boggles my mind. You'd probably be surprised that how much of what I I've heard today that I agree with, because there's a substantial amount of that. The reality is, however, this is a state-centric issue. Not one of our witnesses has talked about the very few individuals who are in the federal juvenile system. I was surprised by that, and yet not surprised. I've been reminded repeatedly about the humanitarian response by the Biden-Harris administration. I have walked recently in detention facilities of unaccompanied minors and putative family or units that there isn't anybody in this room that could say that was humane or humanitarian. I have talked to Border Patrol agents, and I have talked with individuals who have come across our border illegally. The treatment they receive as juveniles is in no way humanitarian. In the district that I live in, contiguous to the Tucson sector, which has the most getaways, by far, more than twice the amount of any other sector on the border. Those are mostly 14 to 25-year-old young males dressed in camouflage, wearing carpet boots and carrying methamphetamine, fentanyl, and bringing it forward. The cartels are exploiting our system. That is why we have raised this over and over today. To ignore that has an impact on how we deal with citizen juveniles is to ignore reality. Ms. Vaughn, how does the TVPRA loophole incentivize non-Mexican parents to send their children to the United States?
The TVPRA incentivizes sending unaccompanied minors here because it says that any arriving minor from a country other than Mexico and Canada is going to be taken from, instead of being removed swiftly as citizens of contiguous countries are, they're taken from Border Patrol custody and put with the Office of Refugee Resettlement into a network of shelters, and that they should be released to a sponsor. That's, the mission of ORR is to find a placement for these minors, either with a family member or a friend or some other unrelated sponsor, often in the foster care system. And so what happens is that the US government essentially completes the smuggling act by moving these kids who get caught and crossing illegally into a placement in the community, essentially to stay.
So, Ms. Vaughn, does the federal government do anything to track or follow these children as they're placed, sometimes with relatives, sometimes not, sometimes with putative relatives, to make sure that those children are safe, okay? Anything else?
After release, there is almost no monitoring that occurs by the government on these placements and what happens to these kids. The sponsors can refuse contact with the government to give an update on the child's welfare. Essentially, the government loses track of them. The kids can move to other households. Many of them don't show up for their immigration proceedings, and we definitely lose track of them.
Thank you. My time is up. Thank you, Madam Chair.
Gentleman's time is up. Gentleman's time has expired. And now recognize the gentleman from Rhode Island. The gentleman is Congressman Cicilline for 5 minutes.
I want to thank you, Chairwoman, for holding this hearing today. And we cannot effectively approach desperately needed criminal justice reform in this country unless we address how the current system is affecting our youth. And I feel particularly connected to today's hearing since my first job as an attorney was a public defender right here in the District of Columbia in the Juvenile Division. And it was my job to defend young people caught up in the system who very often had been failed by the system. And it was my experienced that very often the effort was really made to just sort of shove these kids away so they wouldn't have to deal with them rather than really rehabilitate them. And it was actually what caused me ultimately to enter politics, because I thought we have got to figure out a better way to take care of our kids. And, you know, sadly, to listen to some of the discussion today, you wouldn't think it's our responsibility. I think we have no greater responsibility than the care and well-being of our children in this country. And so I want to first say to Brian Stevenson and Marcia Levick, thank you for your inspiring and heroic work on behalf of America's children. Words cannot describe how grateful I am for all that you've done. And I know there's been a lot of discussion about costs and fees and extreme sentences and excessive punishments and conditions of confinement. All of that is convincing to me. I agree with every single thing that has been said. What I want to focus on instead is how do we prevent young people and children from getting in the system in the first place? Because when we're dealing with costs and fees and extreme conditions of confinement, we've already failed them. They're already in the system. And so all that's fine, and we got to fix it. But, you know, what I'd like to focus on is what kinds of models are there that actually identify some of the trauma that you've described, Mr. Stevenson, or factors that would indicate, you know, the level of trauma that kids are experiencing today is just unbelievable. The fact that we don't have more children in the juvenile justice system is kind of remarkable. And so are there any states that have a model that we should look at that actually intervene early before kids get into either the criminal justice system, the juvenile justice system, that can provide support services at a moment to prevent their entry into a system which is going to gobble them up and very often not do much good for them? So, Mr. Stevenson first, and then Ms. Levick.
Yeah, I think that's a really important question. I began my comments about the trauma crisis because I agree with you that if we do better work at interacting with young kids who are dealing with trauma at very early stages, I actually think we need trauma-informed care at pre-K and first grade, and we can do it. And there are great models. Bruce Perry at Northwestern has done some exciting work improving outcomes for children dealing with trauma. There are a host of programs, purpose-built communities, that was organized in Atlanta, has spread around the country. And what they do is they focus on care and treatment. They try to help kids feel safe, and then they provide environments that help them deal with that. And even when they can't isolate these children from the trauma they face at home, we see remarkably better outcomes for those kids. And so we do have models that are out there that are very effective at disrupting the consequences of unaddressed trauma. If we embrace those, we will see the kind of consequences that you're talking about.
Thank you.
Yes, of course, I echo Mr. Stevenson's sentiments. And I would also add, there are innovative programs in Georgia, there are innovative programs in Philadelphia that are really pulling kids back into their communities rather than pushing them into the justice system from school-related conduct. I think that as we think about, unquestionably, the importance of investing in communities and investing in families and in young people, one of the other ways that I think we're addressing this issue through this hearing today is also about shrinking the youth justice system. And so when we talk about raising the age of criminal responsibility, raising the age of juvenile court jurisdiction, I think the role that the federal government can play in incentivizing the closing of youth prisons, all of that can shrink the system, and I think get at some of the very harms that you've identified.
Yeah, thank you so much. And Mr. Telefoa, I hope I pronounced that correctly. I want to thank you for being here and for the courage you've shown in the work that you've done. And to come before this committee when I was listening to you, it was like listening to a professor. You had so much wisdom. So thank you for being here. And I just wonder if you might comment on whether or not the kinds of interventions that I'm speaking about might have made a difference in your life and the conditions that you find yourself in. And finally, how important it is for the voices of young people to be heard throughout this process. We don't listen enough. We speak a lot to young people, and I think don't listen enough to them.
Yeah, I think really any intervention is great for youth, and then also for youth here, I think really just, I mean, really what I kind of just echo every time I really get the opportunity to speak in front of people is just being able to do what a lot of people out here in Washington are doing, which is coming into the system and finding ways to interact with the youth, get to know them, give them a space, a headspace to really let them kind of mentally escape the confinement that they're in. And so thinking about just ways to let them be themselves, and things like that, I feel like are really key in when we speak about helping youth.
Thank you so much. My time has expired. I yield back, Madam Chair.
The gentleman yields back. Thank you for your inquiry. I'm now delighted to yield to the gentlelady from Texas, Congresswoman Escobar, for 5 minutes.
Madam Chair, thank you so much for this important hearing today. And I want to thank the colleagues and witnesses who have chosen to engage on this issue in a serious and thoughtful manner. I also, Madam Chair, want to register my objection to the continued selection by the minority party of witnesses who belong to an anti-immigrant hate group whose sole purpose it is to spread misinformation and poisonous xenophobia. I represent a district that unfortunately knows only too well that poisonous xenophobia has deadly consequences. But this kind of behavior in our committee hearings is disrespectful of our serious panelists. It's disrespectful of other members and disrespectful of the Americans watching our hearings remotely, because they're looking to us to lead on the topics that we've announced will be the focus of our hearings. I'm going to focus on our hearing, which is the topic is children in our country and the juvenile justice system. I come from local government. I served in local government for almost a dozen years. And in county government, we did some really remarkable things when it came to juvenile justice. And I'm very proud of the emphasis that we placed on rehabilitation and on ensuring that we offered what we called wraparound services with our the young people in our custody. And our panelists who've given us so much wisdom, I want to thank you all so much for what you've shared with us. But I do, Aaron, I want to turn to you because I'd love for viewers and colleagues to listen to your thoughts on how we can best wrap our arms around young people from the time of birth on forward. You know, some of my colleagues who've stated that the federal government doesn't have a role in juvenile justice. We have a role in creating a country that offers access to health care, mental health care, education, housing, quality child care, and so many other things. Aaron, can you share with us and with those folks watching this hearing, where in your life do you think we could have, as a community, as a society, done better to help you have more opportunity or a better chance, a different path, so to speak?
So just reflecting on back when I was out, I think I started going, so to speak, downhill when I was in school and I wasn't doing so good. And I think right then and there, I could have been identified as, you know, at risk. And someone could have came and helped me and said, hey, like, you know, what's going on? And just the school system, how it was, I didn't really, you know, I wasn't really able to just sit there. You know, I'm more energetic and I like to, you know, be hands-on and do things. I think a lot of guys that I'm here with, they would say, you know, their favorite class in school is PE. You know, you're able to, you know, actually do what you know, you're learning. And so just thinking about the different styles of learning. Also, one thing that is funny is when we talk about learning, some people don't know how to learn or which way of learning is best for them. And so teaching someone how to learn, which sounds funny, but it's a thing to teach young people is what they're best at, how to learn as effective as possible. So just prevention period, really, many ways, I feel like I could have been helped. Thinking about just, you know, being where I'm from, how I was raised and brought up and seeing the things that I've seen and really thinking like, you know, this is what it is for me. So I'm gonna, you know, repeat what my cousins and my older siblings were doing. And so thinking about giving youth a different environment or a different person to look up to, and seeing different outlets of their situation. So
Thank you, Aaron. I really appreciate you sharing that with all of us. Mr. Stevenson, I'm running out of time, but I really do appreciate. I wanted to ask you about what you mentioned with regard to bias, and what we continue to see in our country, unfortunately, is a poisoning of the public against certain groups, certain individuals. We're seeing that in this hearing with a desire to try to create an image that immigrants are criminals, associated with criminals. This desire to link certain groups in the most negative way. But we'll get into that another time. I thank all of you so much for sharing your wisdom, your brilliance, and your compassion. I yield back.
Gentlelady yields back. I have some clarifying questions, but I'm going to yield to the ranking member for his time, and I'll be very brief on two or three witnesses for the record to clarify. Thank you. Mr. Biggs, you're recognized.
Thank you, Madam Chair. I appreciate that, and I appreciate the opportunity, because what I just heard from a member of our committee accusing the minority's witness as being racist and xenophobic, that is such a canard in today's world. If you oppose illegal immigration, somehow that makes you a racist or a xenophobe. That's outrageous. This country is very welcoming. There isn't anybody I know that doesn't support at least some form of legal migration. And what we've seen last year, even during COVID, 1.7 million people legally were brought into this country. The year before, 2.2 million. And that's the way this works. But I appreciate the chair, because what she's trying to get at is to show deference and respect to the witnesses who appear here, who come, make efforts to come and put themselves out. It cannot be easy to sit in front of so many of members of Congress who we all have our egos, we all have our political ambitions or political motivations that drive us. It can't be easy. It's not easy for anybody here who's come and testified today, and where I'm very appreciative for everybody. I mean, I'm trying to find what I agree with out of everyone. But I mean, this kind of denigration, that right after our own chair has essentially, I won't say reprimanded, but made comment about one of my own members, to have the very next member of this committee make those kind of outrageous and inflammatory statements about our witness, I think is ridiculous and absurd, and it's unfortunate. The reality is, many of us on the minority side, we looked at this as what I've characterized before is this notion that it's a state issue. But most of what this is happening is a state issue. We've seen Utah's done great. I could go through reforms Arizona has made. I could go through the Arizona data. I've pulled it up and looked at it. I mean, we could talk about that, but that's really belongs to the states. Trying to find the unique things that belong within our jurisdiction, that's what I would be more willing to do. But at the same time, what is in our jurisdiction, clearly, this particular subcommittee, as well as our overall committee, is what's happening on the border. I just got back from the border again last week. I cannot tell you how many times I've been on the border this year. I'll be back on the border next week. I'll be back down on the border the following week. It is a real issue, and it deals with juvenile criminality and the system that we have dealing with juvenile crime, whether it's good or bad. It unfortunately flows right into it. That's why I mentioned that if you were to look at Arizona data, you're going to see at least a very small number of official discharges to ICE, but there'll be also, not broken out, is demographic groups that come from people who are illegally in this country that have somehow found themselves in our system in Arizona. These things are important, and to ignore them when, and I cannot stress this enough, in April, 178,000 encounters. That means apprehensions. Known getaways, about 40,000. Unknown getaways estimated to be an additional 100,000. If you have 300,000 people coming into your country every month, like we have for the last 3 months, and which are projected for the next 6 months, that is virtually going to impact every system that you have in your society, including your juvenile system. That is why we raised it today. I am unapologetic for raising it today. I appreciate the witnesses who've testified. You've given me seeds for thought and consideration, and I appreciate that. And I thank you, Madam Chair, for letting me have this few minutes to clarify.
Mr. Ranking Member, I hope that we will come away from this hearing where all of us will say that we're committed to helping children. You indicated such. I want to take this moment and I'm going to pose some very quick clarifying questions within my time frame. So if the witnesses can listen so that we will conclude the hearing. But I do think it's important again to state that gangs and immigrants are not synonymous. ICE-owned data belies that prior administration's attempt to criminalize immigrants. Historical data on ICE gang enforcement operations show that 60 to 80% of alleged gang members are U.S. citizens. And so claiming that unaccompanied minors or others contribute to the gang problem, I think that we can find ways to resolve this in a different manner. We understand the crisis, and some of us have the perspective that the Biden administration is working on it in a humanitarian way. But I want us to focus on where we are today, and I thank the ranking member and his members for being here. But I want to pose this to Mr. Stevenson and Ms. Levick, very, very keenly focused on Miller and what we have done with this Jones decision in terms of juveniles' life without parole. What kind of inhumane impact does this have on a child when they have this kind of sentencing? And if you might, in the juvenile system that we have today, not talking about states that have done well, we don't correct it, how many of our children will we lose? Mr. Stevenson first, Ms. Levick. I have a quick question for you, Mr. Peterson, and a quick one for you, Aaron. I hope that I'll be able to get it within my time. Mr. Stevenson first.
Yes, I don't think there's any question that life without parole for a child is devastating. When we sentence someone to life without parole, we don't actually allow them to have programming. We don't allow them to get access to education. We don't allow them to participate in the rehabilitation programs that exist. That's one of the reasons that Justice Kennedy was so oppositional to this kind of sentence for a child. And we do have lots of states that have continued to use this sentence. We have hundreds of people who've been released as a result of Miller, and 99% of them have done extremely well. That's the evidence that I think supports what the court did in Miller, and why what the court indicated in Jones is something that should be pushed away as we continue to eliminate and abolish life without parole for all children in this country.
Thank you, Mr. Stevenson. Ms. Levick, very quickly.
Yes, I think the good news is that the vast majority of men and women who've been resentenced since Miller and Montgomery have not been resentenced to life without parole. And hundreds of them have come home and are doing incredibly well, and many of them are contributing to their communities. But I think that what Jones does is it certainly makes it easier to impose a life without parole sentence going forward. That is a sentence to die in prison, and I think that the solution to that is to abolish life without parole.
I thank you, Mr. Peterson. Your state has been stupendous, but we're the only country that has not ratified the Convention on the Rights of Children. Can you talk about the idea of human rights for children and the idea that we have not, in essence, ratified it from your context, the importance of human rights for children?
Yeah, I think it's critically important. At the end of the day, these are children. They are kids. And when you spend time with them, and I heard Congressman Owens reference his time in our facilities, and he's seeing Aaron here today, that's what you recognize. You come to hear their voice, you recognize and identify that need for the acknowledgement of human rights for all children.
Aaron, are you going to be, besides my voice, and excuse me, Mr. Tolofoa, our last voice, because you are our important voice. Help us understand, if you want to share a little bit about what you did, but more importantly, how you are different today than you were at the time that generated the acts that caused you to be in prison or in jail in your facility today. How are you different today, Mr. Telefoy? Tell us from your heart.
So yeah, back when my crime was committed, I was reckless. I was doing stupid things. In the end, affecting my victims how I did, and it was horrible, you know. And I think for me, so I was sentenced to 21 years, but for me, thinking about my victims, it wasn't that, okay, you know, I was sentenced to 21 years and that's it, you know. For me, it was more of, okay, I can easily go through my whole entire 21 years and just come out and be the same person that I was when I walked through those doors. But for me, it was, how can I become better so that I can infect change upon others, so when they get out, victims like mine, people aren't going to be experience what they experienced. So for me, it was just a matter of really reflecting on back on my actions and thinking I didn't want that to happen to anyone else. So for me, how I could repay my victims, how I could attempt to restore that is by bettering myself, not becoming worse while I'm inside the system, but becoming better. So when I return to the community, I can help people who were once in my shoes not repeat those actions. And so for me, it's just, that's a passion of mine. And so when I see youth come in here, I'm just like, you know what? You got two choices. You can either return back to the streets and be on your way right back in, or you can, you know, better yourself. And so for me, that was just a journey that I had to really go forward on and just really think about, you know, my past actions and what do I want for myself and how can I better myself for my victims. That way, you know, I'm not just serving this time just to do it and get out and return right back to the institutions.
Mr. Telefoy, your last voice, your strong voice indicates why we came here today on the juvenile justice pipeline and the road back to integration. It also emphasizes why we as Americans, why this nation has to be able to save our youth. I am grateful to the witnesses who have come and given us that pathway. Ms. Stevenson, continue your fight for equal justice, and we will work alongside of you. Ms. Levick, continue your journey, and we will stand alongside of you, and I believe we can do it in a bipartisan manner. Mr. Peterson, you have a unique and effective approach in Utah. I believe we can follow that on the federal level. Mr. Telefoy, again, most eloquent and powerful. I wanted you to have the last word. Ms. Vaughn, we welcome all opinions in this committee, and at this time, with no further business, the committee now stands adjourned. I think we can talk. Oh, you went out. Thanks, Brian. Can you hear me? Go.
Yes, Chair. Thank you. It's great to be with you.
Good. I wish the best for your graduation.
Thank you very much. I appreciate it.
Aaron
Yes,
has left,
yes,
so we thank him, and we'll thank all the others.